distinguished guests, ladies and gentlemen. A very good morning and a warm welcome to the Asian International Arbitration Center, more commonly known as the AIAC. Also, the AIAC is the Kuala Lumpur office of the ADNDRC. The AIAC, in collaboration with the Hong Kong International Arbitration Center, HKAIC, China International Economic and Trade Arbitration Commission, CITEC, and the Korean Internet Address Dispute Resolution Committee, KIDREC, or KISA, is proud to host the ADNDRC Annual Conference 2023 in Kuala Lumpur, Malaysia. We're pleased to welcome you all here today and our 300 virtual participants who are joining us online on Zoom. With the surge of artificial intelligence and the dawn of Web3 domains worldwide, this year's conference will see diverse international panelists discuss the impact of the latest trends in domain name dispute resolution sphere. Join us as we forge into the future and hear from experts on the procedures offered by the ADNDRC and our best practices. With that said, on behalf of the ADNDRC, we're truly pleased and honored to be able to welcome you all today. To begin the event, we would like to call upon the director of the AIAC, Datuk Sundra Raju, on stage to deliver the welcoming remarks. Please welcome Datuk Sundra Raju.
Very good morning to everyone, especially present and virtual. Datuk Professor Dr. Rahmat bin Mohamad, Chairman of the AIAC Advisory Board, Mr. Wang Chen-ji, Chairman of ADNDRC, Mr. Eric Ng, we are great pleasure to meet you today, Deputy Secretary General of Hong Kong International Arbitration Center, Mr. Yoon and Mr. Shi from Korea, and distinguished guests, esteemed colleagues, ladies and gentlemen. As I said, it's a very good morning today, and I thank all of you all for joining us in this historical Bangunan Sulaiman. I think Eric would have been the first time you're here. So it is actually historical in the sense that it is part of Malaysia's history. This building used to be the center, nerve center of British Malaya, the second railway headquarters. The entire infrastructure of what Malaya at that time became and subsequently what it is now started from here around this precinct. And I also see James Dinga, my old friend and comrade in arms. It's a tail end of the year, and I thank all of you all for being present here. Especially the auditorium is filled up. We have a number of online participants. And I also want to thank the officers, the other officers of ADNDRC, particularly from Hong Kong, from China, CITEC, who CITEC is now the chair, then from Korea is here, and then of course from Malaysia. And then we are co-organizing this conference. And it is themed this year, Breakthrough, Bypassing Digital Boundaries. And when organizing this conference, I still remember we started off quite tumultuously when I first came back and I attended the council meeting, and I think we started off on a wrong foot, but we are trying to make amends and trying to get moving so that we can work together. I think I think that's the most important thing. I was the chairman of ADNDRC in 2018, and I know what the potential of the alliance could be. And it is the only alliance in the world that represents in Asia, which is a very important thing because 4 arbitral institutions came together to apply, the ICANN license came from, and then we applied as an alliance. I think it is also a testament of cooperation. So we are one of the 4 service providers for ICANN in the world, and the only one in Asia as is under the to provide dispute resolution services for for generic top level domain names, and we actually operate out of Hong Kong. Hong Kong, and the website is a common website. It's a thing that we did, I believe, in 2009. That's quite a long time ago when the alliance was formed. 2009, when I came to as director the last time, 2010, the alliance was there, but it was not so active. Not so active. I think now it's more active, and then it is the way we operate is that there is a council, and the council consists not only members from the institutions but also members who are outside the institution. And I believe Dennis would be here. And Dennis is one of the old veterans from Hong Kong. He was Deputy Secretary General of Hong Kong, and he's still around. He's moving from institution to institution, but more importantly, he has always been around, and he has a better understanding of the history of this particular alliance. And then we have been quite active, as I say, and I always come back to this theme about our century. We are now in 2023. This is the century of Asia. And when I say it's the Asian century, is that this is where a lot of things are going to happen in Asia. Because the economic power has shifted. It has shifted to Asia. And in that way, when economic power shifts, economic activity shifts, cross-border trade and globalization increases, the most important thing is that there must be some way of resolving disputes. And the resolution of disputes always comes from arbitral institutions, lawyers, stakeholders deciding and using particularly arbitration, because arbitration is cross-border enforceability, the universal enforceability under the New York Convention. So the growth of domain name disputes have remained constant. In fact, I think it's starting to grow. Our lives are now governed by the internet. Just imagine if you do not have internet connection. How do you feel? You feel as if you have lost your bearing. In the old days, we will actually go back and type out our letters and fax it through. In fact, I think many of y'all will not have known how a fax machine looks like now. I think my time, the Prof, our time will be telex machines. I think that one you definitely all won't know. So I think nowadays, we have this domain name. Domain name disputes is simply because of the strength of the internet and the pervasiveness of the internet. And there is actually ownership arrangements. And sometimes people take advantage. It's just like, land law. I always compare the internet with whatever we have physically, but differently, because it's in a different dimension out there, but it is still something, whereas let's say when you build a house, you have a piece of property, you have a piece of land, you put up your house. So when you have a website, it's a similar situation. You have some kind of proprietary ownership of the and some rights to it. And of course, when somebody tries to take that away, and sometimes people are very entrepreneurial, they tend to actually anticipate and try to mimic, and sometimes even cyber squad, they do that. The courts in Malaysia particularly have been generally receptive to ADR mechanisms, and there is no difference where domain name is concerned. They have been they have been actually supportive. In fact, we have a case, Jun Z Wang and another versus TC Pharmaceutical Industries, where the court held that it has no jurisdiction to review or set aside a decision of an administrative tribunal on a complaint filed under ADNDRC UDRP procedure. This is a case in point, recognizing the actual dispute resolution system that is provided by us. So, and then I think we I think every jurisdiction, country-based, polity-based, jurisdiction-based, normally you will have a service provider, sometimes a few service providers, but here we have MyNIC, and we are the main service provider for MyNIC.my. And then I think, to really talk about the future is that technology is changing, it is advancing, and cyberverse is becoming a very important dimension in our lives, and it is very positive. I think we have to look at it very positively, and things like artificial intelligence, the debate about the morality of and then the ethics and where will it take us. I don't know whether the domain name decision making will soon be artificial intelligence. You may just put in because domain name, when you look at the awards, they are actually quite straightforward. I noticed that there is a set procedure, and I'm quite sure that if you actually feed the thing into Chat GPT, you will get a reasonable answer, which you then try to improve it and see whether the answer is correct. So I can see things like that going to happen, because because you need to decide in a very short time. The information is actually standard. The decision making is also quite standard. So it is. I've been watching this for many years, and I've been looking at the decisions that come out from the tribunals, the sole tribunals. So I'm very interested to see how the new tools in artificial intelligence is going to help us improve our decision making, and also improve the timeliness, and therefore the cost should go down. But of course, we will not cut the cost of the poor arbitrators who are paid already very low, where I can disputes are concerned. So I wish you all a very good conference, and thank you so much for attending in person and virtually. Thank you.
Thank you, Datuk, for your welcoming remarks. Distinguished guests, ladies and gentlemen, may I please draw your attention to the screens for the opening remarks provided by the chairman of the ADNDRC, Mr. Wong Cheng Jie, who will be joining us virtually. Thank you.
各位来宾、女士们、先生们、朋友们，大家上午好。很荣幸代表亚洲渔民争议解决中心，也就是亚渔中心和中国国际经济贸易仲裁委员会，欢迎各位演讲和研讨嘉宾，以及现场和线上参会的各位朋友，参加2023年亚渔中心年会。首先，请允许我借此机会感谢各界朋友多年来对亚渔中心的大力支持，对渔民争议解决事业的关注与支持。要感谢各位资深渔民专家、嘉宾在今天年会上做精彩的专业分享，同时也要感谢亚洲国际仲裁中心，也就是 AIAC 共同主办本届年会，感谢亚渔中心北京、香港、首尔和吉隆坡4地办公室长久以来的共同努力。2002年，亚渔中心由贸仲和香港国际仲裁中心，也就是 HKIAC 共同创立，是 ICANN 授权的世界6家通用顶级域名争议解决机构之一，同时也是亚洲第1家通用顶级域名争议解决机构，成为引领亚洲域名争议解决发展的先行者。此后，韩国的 ADNDRC 和马来西亚的 AIAC 相继加入，亚域中心以北京、香港、吉隆坡和首尔4个办公室服务亚洲，辐射全球。去年，亚域中心迎来了自己的20岁生日。经过超过20年在域名争议解决领域的深耕和实践，亚域中心共处理了数千件域名案件，涉及当事人近50个国家和地区，为亚洲乃至全世界的商标持有人提供了多语种、多地域、多管理机构选择的域名争议解决服务。从域名案件处理、专家队伍建设、规则和实践创新等方面，为整个域名争议解决事业的发展做出了重要的贡献。亚域中心近年来在推动域名争议高效快速解决、促进数字经济稳健发展方面做了许多的工作。亚域中心一直非常注重机制建设和机构发展，不断优化管理结构，为案件管理和业务发展打好基础，不断探索提高域名争议解决质量和效率的路径，寻求最优域名争议解决实践。同时，亚域中心也非常重视专家队伍建设，通过完善专家的遴选机制，加强专家培训和出台裁决写作指引等工作，提升专家队伍的专业性、国际化和公信力。茂众作为亚域中心的创始机构之一，作为亚域中心现任主席人事单位，积极参与及引领中心管理事务，为亚域中心争议解决的发展发挥重要的推动作用。未来，亚域中心各办公室仍将精诚合作、紧密联系，确保亚域中心的各项工作有序展开，为互联网的健康有序发展提供有力的法治保障。本次年会的议题，一方面聚焦域名侵权的实体权利保护和域名争议解决的最佳实践，另一方面重点关注域名注册和争议解决面向未来技术革新、人工智能迅速发展和对数字安全要求更高的新时代，应如何发展和应对新挑战。在当今的时代背景下，对这些议题的讨论具有重要的现实意义。我们知道，科技发展和数字安全是一箭之双刃。在科技蓬勃发展、人工智能也就是 AI 大行其道的数字经济时代，人们一方面享受着科技发展带来的以空间换时间的便利，另一方面也承受着科技发展带来的网络安全方面的隐患。这些技术在仲裁和调解领域已触及包括区块链案件管理、文件管理自动化存档、云存储、人工智能技术、自然语言处理和可视化工具等方面。中国信息通信研究院最新发布的《中国数字经济发展报告》2023年显示，2022年我国数字经济规模达到50.2万亿元，同比名义增长10.3%，已连续11年显著高于同期 GDP 名义增速。数字经济占 GDP 比重相当于第二产业占国民经济的比重，达到41.5%。数字经济的发展催生了对与之相适应的数字化纠纷解决方式的需求，争议解决服务和机构都需要进行数字化转型，而其中数字安全是不可或缺的关键。联合国贸法会第2工作组也曾就数字安全展开了深入的研讨，在身份认证、电子签名、数据安全等领域达成了初步的共识。因此，新时代为域名争议解决带来新挑战、新问题。 我们应当如何应对，化挑战为机遇，在变局中开新局。今天非常期待各位专家学者分享他们的真知灼见。我们相信，数字经济时代，域名争议解决市场更加广阔。域名中心的4个办公室将齐心协力，共同推进域名争议解决事业的发展。我们将继续充分发挥自己的经验优势和专业优势，加强域名专家队伍建设，不断提升裁决质量，保障当事人合法权益。我们将守正创新，利用技术赋能，提高办案效率，优化办案流程，进一步提升当事人的服务体验。我们将继续大力宣传和推广域名争议解决机制，加强国际交流与合作，提升亚域中心的国际公信力和竞争力。亚域中心愿意与各界一道，不断完善域名争议解决机制，加强知识产权保护，促进网上争议解决理论和实践的发展，为数字经济的健康有序发展发挥积极作用。最后，预祝本次会议圆满成功，谢谢大家。
Thank you to Mr. Wang Qingjie, and we hope that we will be able to host you here physically at the conference in the future. Thank you. Distinguished guests, ladies and gentlemen, without further ado, we'd like to call upon Professor Datuk Dr. Rahmat bin Mohammed, Chairman of the AIAC Advisory Board, to deliver the keynote remarks. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. A very good morning, Dr. Sundaraju, the Director of the AIAC, Mr. Wang Qingjie, the Chairman of the ADNDRC, distinguished guests, esteemed colleagues, ladies and gentlemen. As the Chairman of the Asian International Arbitration Center, AIAC, Advisory Board, I am honored to be here at this prestigious event organized by the AIAC alongside the officers of the ADNDRC, HKIAC, CTAC, and KISA. The ADNDRC annual conference has been the highlight of the domain name dispute field in Asia for some time, and the previous editions of the conference have been memorable, serving to highlight the strength of our alliance. I understand the field of domain name dispute resolution within Malaysia has existed for some time, with the nation producing many experts in the field who currently sit as panelists for both UDRP and MyDRP matters, rendering sound decisions. However, this subset of ADR does not seem to have caught within Malaysia. This conference served as a timely refresher of the wide impact ADNDR will soon have in all aspects of our commercial undertakings. That being said, the conference was organized with the intent of highlighting the real and present danger that registered domains face on a daily basis. The ADNDRC's rules and best practices from the perspective of the ADNDRC officers, ongoing trend in domain name disputes, and the emergence of artificial intelligence. The challenges we face in this modern digital domain are complex and multifaceted. They require not just legal and technical expertise, but also a deep understanding of the evolving digital culture. Our diverse experiences and commitment to innovation position us uniquely to address these challenges and turn them into opportunities for growth and development. Our alliance, comprising AIAC, HKIAC, CTEC, and KISA, is more than a coalition of organizations. It is a confluence of diverse perspectives, experiences, and legal traditions that enrich our collective approach to digital dispute resolution. This diversity is our greatest strength. Each office brings unique insight and methodologies that, when harmonized, create a comprehensive framework capable of addressing the multifaceted nature of digital disputes. The IAC, with its pioneering efforts in developing arbitration and mediation rules, offers a structured yet flexible approach to conflict resolution. HKIAC's reputation for integrity and efficiency in handling complex cases contributes to our alliance's credibility. CTEC's vast experience in resolving international trade disputes provide a global perspective essential in our interconnected digital age. Lastly, KISA's expertise in internet security and digital forensics equip us with the technical acumen necessary for resolving sophisticated cyber-related disputes. The synergy of these institutions creates a holistic dispute resolution mechanism that is adaptive, culturally sensitive, and technologically advanced. By pooling our resources, sharing best practices, and fostering a collaborative environment, we are setting new standards in digital ADR. This alliance is not just a platform for resolving disputes. It is a catalyst for developing future-oriented policies and practices that anticipate and address emerging challenges in the digital domain. To that effect, I would like to echo the sentiments of the director of IAC, Datuk Sundaraju, that this century is the Asian century, and we would be able to capitalize on this opportunity only through strong relationships within the region. As mentioned earlier, the topics of this conference have been carefully chosen based upon the ongoing debates and trends within the ADNDR sphere. On that note, do allow me to briefly highlight the importance of domain name dispute resolution and some trends that would be helpful to be kept in mind throughout this conference. Ladies and gentlemen, in this digital age, domain names are akin to virtual real estate, holding immense value and significance. The escalation in domain name disputes is a byproduct of the digital economy expansion. As businesses and individuals increasingly rely on the internet for commerce, communication, and identity, the demand for distinctive and relevant domain names escalates, inevitably leading to conflicts. Domain names are more than mere internet addresses. They are critical for brand identity, marketing, and maintaining a digital presence. A domain name dispute can have far-reaching consequences, from financial losses to reputational damage. Hence, efficient and fair resolution of these disputes is not just a legal necessity, but a business imperative. The complexity of these disputes often stem from the cross-jurisdictional nature of the internet, necessitating a nuanced understanding of different legal systems and cultural contexts. the ADNDRC strive to balance the interests of all stakeholders through the administration of DNDR proceedings under its license granted by ICANN. Recent trend in domain name cyber squatting have indicated a concerning increase in the use of sophisticated methods and technologies. Cyber squatters are no longer just opportunistic individuals. They are often part of organized network, employing advanced tools to automate the process of identifying and registering potentially valuable domain names. This automation has drastically increased the scale and efficiency of cyber squatting activities, making it a more significant threat to the integrity of the digital marketplace. Some of these networks often use algorithms to scan for upcoming product launches, trending topics, and emerging brands, quickly registering related domain name before the legitimate owners can do so. This preemptive registration not only infringes on intellectual property rights, but also disrupt fair market competition. Moreover, the use of proxy registrations and hidden ownership details make it increasingly challenging to identify and take action against these cyber squatters. Another worrying trend is the use of domain names in phishing schemes and fraudulent activities. Cyber squatters are registering domain names that mimic those of reputable organizations to deceive consumers and steal personal information. This malicious use of domain names not only causes financial harm, but also erodes consumer trust in online transactions. Furthermore, raising awareness among businesses and the general public about the risks of cyber squatting and the importance of proactive domain name management is therefore essential. Educating stakeholders on the value of domain name and the need for vigilant registration practices can significantly reduce the opportunities for cyber squatters to exploit. The prevalence of artificial intelligence in internet domain is a topic of pivotal importance in today's digital landscape. AI is not merely a tool for efficiency. It is a transformative force reshaping how we approach domain name management and dispute resolution. The integration of AI into these processes is not just about leveraging technology for operational gain. It represents a significant paradigm shift in our approach to digital challenges. AI's capabilities extend far beyond simple data analysis. Advanced machine learning models are now capable of predicting trends, identifying potential legal issues, and even suggesting resolution based on vast repositories of legal precedents and case law. These AI systems can process and analyze data at a scale and speed unattainable by human arbitrators, providing invaluable insight that enhance decision-making processes. Moreover, AI roles in enhancing the accessibility and efficiency of dispute resolution processes cannot be overstated. By automating routine tasks, AI allows arbitrators and legal professionals to focus on more complex aspects of cases, leading to more thoughtful and nuanced decision-making. Additionally, AI-driven platforms can offer user-friendly interfaces that simplify the process for all parties involved, making dispute resolution more accessible to non-experts. However, this increasing reliance on AI also necessitates a robust framework to address potential ethical and fairness concerns. We must ensure that AI systems are transparent in their operation and decisions, and that they do not inadvertently perpetuate biases or inequalities. This requires ongoing collaboration between technologists, legal experts, and ethicists to continually assess and refine AI systems, ensuring they align with the highest standard of justice and fairness. In essence, the integration of AI in domain name management and dispute resolution is a journey towards a more efficient, equitable, and accessible digital legal landscape. As we continue to harness AI potential, our focus remains steadfast on maintaining the delicate balance between technological advancement and ethical responsibility. I understand that the esteemed panelists will be discussing this topic in a greater detail in the third session, and I'm sure that this topic will be of utmost importance for all of us moving forward. The advent of Web3, a new iteration of the World Wide Web based on blockchain technology, introduces a novel concept of domain. Web3 domains are decentralized, blockchain-based, and user-owned, contrasting sharply with the centralized nature of traditional domain name system. This decentralization promises enhanced security, resistance to censorship, and greater user control. However, Web3 domains also bring unique challenges. The lack of centralized authority complicates dispute resolution. The traditional mechanism of enforcement and control do not apply in the same way, necessitating a rethinking of our strategies and tools. In conclusion, we stand at the precipice of this digital breakthrough. Our role as leaders, arbitrators, and innovators is more crucial than ever. The path ahead is laden with challenges, but it is our collective strength, wisdom, and foresight that will guide us in transforming these challenges into opportunities. Together, I'm sure the ADNDRC will continue to safeguard the integrity of the digital realm and ensure that it remains a space of equitable and fair opportunities for all. Now, in relation to free speech and criticism in internet domain name dispute, that warrants our attention is a delicate balance between protecting intellectual property rights and upholding the principle of free speech and criticism. In the realm of domain disputes, the line between a legitimate critique and infringement of a trademark can often be blurred. This intersection poses a unique challenges for arbiters and policymakers in the digital domain. Phishing attacks using registered domain names have also become a prevalent threat in the digital landscape, profoundly impacting businesses and consumers alike. These malicious activities involve the registration of domain names that are deceptively similar to well-known brands or legitimate websites, with the intention of deceiving users into revealing sensitive information. The impact of phishing on registered domain name is multifaceted. For businesses, it not only leads to direct financial losses through fraud, but also damages brand reputation and consumer trust. When customers fall victim to phishing scams under the guise of legitimate domain names, it erodes their confidence in the digital presence of a brand, leading to a loss of business and credibility. For consumers, the consequences extend beyond financial loss. phishing attack can lead to identity theft, unauthorized transaction, and a breach of personal privacy. These incidents not only have immediate repercussions, but also have long-term effect on an individual digital security and trust in online transaction. The sophistication of these phishing schemes is continuously evolving, with attackers employing advanced tactics such as using SSL certificates to make phishing sites appear secure, or exploiting homoglyphs to create domain names that are visually indistinguishable from legitimate ones. This evolution makes it increasingly challenging for both users and domain name authorities to detect and prevent phishing attempts. In response, there is a growing need for collaborative effort between domain name registrars, cybersecurity experts, and legal authorities to develop more robust detection and response mechanism. This includes enhanced verification processes for domain registration, proactive monitoring for potential phishing activities, and swift action to shut down malicious sites. Furthermore, public awareness and education are crucial in mitigating the impact of phishing. By empowering users with the knowledge to recognize and report suspicious domain names, we can build a more resilient community against these malicious threats. The fight against phishing is not just a technological battle, it's a collective effort that requires awareness, vigilance, and collaboration. In conclusion, as we move forward, let us remember that our action and decision have far-reaching implications. Our team of breakthrough, bypassing digital boundaries, the ADNDRC are not only aiming at resolving dispute, we are shaping the future of the digital world. Our journey does not end with this conference. It is a continuous process of learning, adapting, and leading. Thank you once again for your dedication and commitment to this cause. Together, we will break through digital boundaries and create a legacy of digital harmony and justice. I thank you.
Thank you very much, Professor, for your speech. Before we proceed to our first session of the ADNDRC annual conference, let us take a short networking break and we'll resume here at the auditorium at 10:40 a.m. Light refreshments are served at the pre-function area next door. Please follow our ushers outside. Thank you. Distinguished guests, ladies and gentlemen, we're now going to move into the first session of our event, titled Where There's Smoke, There's Fire, Discovering Infringement. With that, I'd like to call upon the moderator, Mr. Bahari Yao of RDS, on stage to kickstart the session. Joining him on stage are Ms. Wong Jin Ni of Wong Jin Ni & Teo, Mr. James Dingra of Tiberius Management Consultants Singapore, and Ms. Leslie Lim of Ma Wing Kwai and Associates Malaysia, who's standing in for Mr. Raymond Ma, who unfortunately fell ill and could not join us here today. Ladies and gentlemen, please welcome your panelists on stage.
A very good morning to all of you, ladies and gentlemen, boys and girls. Welcome to the first session. We are going to talk about where there's smoke, there's fire, and discovering infringement. Now, we have three well-known and esteemed speakers with us in the first session. Now, before we start, in fact, we had serious discussion over the last week. culminated to the last where we spoke yesterday. And I said, for the purpose of time management, I said each of the speakers, unfortunately, is given only 20 minutes. So James and I had this exchange. He said, there are so many things to talk about. I don't care about your 20 minutes. I said, okay, never mind. I give you 23 minutes. He said, you said all the time you want. So I said, 25? He said, you can. I said, 25 minutes. If you don't finish, I'm going to walk out to you and snatch the mic from you. And he said, you can snatch. My voice is loud enough and I will continue talking. You may need to call security guard. So hopefully there's no arbitration sessions after this panel. Now, the esteemed speakers need no specific introductions. They're all very humble people and they asked me, because I've given them 20 minutes, they said, keep my introduction short. But I will do justice a little by just briefly introduce all of them to you. Now, I will start off with Wong Ginny. Wong Ginny graduated from Sydney University many, many years ago. She was admitted as the barristers at law, Supreme Court, New South Wales. She is a well-known figure in the IT industry since her admissions as advocate solicitors in 1991. She's a registered trademark, patent, geographical indication, industrial design agent in Malaysia, served many committees, including the IP Committee of Bar Council, Committee of Malaysian Franchise Associations, the first batch IP valuers trained by MIPO, and certified by the World Trade Institute, Switzerland. I mean, Ginny is known to us to be a very capable IP and IT lawyer. Now, we are also fortunate to have James, a very lengthy CVs. If I got to introduce all his success story, I think that will be the end of today's session. So just let me very briefly, he worked and consulted in various industry. In terms of his professional affiliations, he's a fellow ACICA, panel arbitrators, WIPO, ADR neutral, and PEN as an arbitrator with 20 years of international arbitration centers. He's a member of SID and a chartered valuer and appraiser. He has published a lot of papers and presented many, many sessions. That's James. Sorry, that's very brief because James is going to snatch the mic from me if I go beyond 3 minutes. Now, Leslie. Leslie is a substitute because unfortunately her partner is down with flu. He said he doesn't want to cough during this session. So, but equally capable and well-known, Leslie. She was accorded the Women Lawyer of the Year Law Firm 2020 by Asian Legal Business Malaysian Law Awards. She's a National Sports Institute of Malaysia Research Decisions Ethics Committee member, and she's also the National Dispute Resolution Chambers of Football Associations Malaysian FAM member. Now, for the purpose of today's, sorry, again, brief because 3 minutes rule. Now, for the purpose of today's session, maybe I'll just give you a heads up. Of course, I'm a bit fortunate than you. I had read the slides what they proposed to be talking about today. I can assure you, very interesting. Ginny is going to start off by giving you some perspective from the Malaysian angle. She is going to talk about some dynamic approaches and some of the resolutions from the past and the future, looking from the lens in Malaysia. Then we have James. I particularly like the one of the way James put, that the sessions is where there's smoke, there's fire. And I like the way he defined fire. Now, basically, I'm not going to spill the secret now. I'll let James do that. But he's going to talk about infringement in the borderless world of e-commerce and open AI online marketplace, and from the global perspective. Yeah. And finally, Leslie, she is going to talk about the future Web3 and whether that offers some solution that brings us to the future. So with that, I believe my 3 minutes is up. Ginny, the stage is yours.
Good morning, ladies and gentlemen. First of all, I would like to thank ADNDRC for inviting me to be one of the panel speakers for this very interesting topic and metaphor. Since we are in Malaysia, I thought it's befitting for us to start with the Malaysian experience to kickstart the session. So briefly, this is the agenda of my presentation. And I would like to start with something quite fundamental, and I'm sure everyone here is quite well versed with the differences between domain names and trademarks. But I thought it would be quite good to provide a foundation to kickstart the discussion. So if you look at the nature and function of domain names essentially are human readable alphanumeric strings to facilitate online access. Trademarks, on the other hand, they are signs which could include words, brands, numerals, or a combination thereof to distinguish goods or services of one undertaking from another. And it functions as a source identifier or trade origin of those goods or services. And the differences in the registration system is very important for us to look at it because it could be the cause of the dispute, the domain name disputes. For domain names, generally, they are registered on a first-come, first-served basis without examination through an accredited registrar. On the other hand, trademarks are registered after search and examination processed by an IP office. In Malaysia, it would be Malaysian IP office, which is a governmental agency. So putting aside bad actors like the cyber squatters, like the typo squatters, there are reasons for domain name disputes. And a lot of them would be stemmed from the registration system, because domain names are registered on a first-come, first-served basis, whereas trademark registration are based on prior search and examination. And trademark rights, are limited to the country where you obtain registration, right? And trademark rights are also obtained only in relation to specific goods and services, unlike a domain name, right? So you have competing business interests. So businesses in different business space or different industries are all vying for the same domain name, identical domain name. And because of the evolving digital landscape, domain names now serve as valuable business identifier, right? They influence brand recognition. They provide online visibility and provide the consumer with trust and confidence when they, deal with a particular entity. And when it comes to the bad actors, there are various forms of, activities that the bad actors could engage in. We heard of cyber squatters, typo squatters. You can do the domain name in a reverse order, geographical variation, as well as other forms of malicious and criminal exploitation of the domain name system. For example, parasiting, phishing, scamming. And the impacts and the effects are substantial. I mean, we heard from Dr. Rahman earlier about the effects. These are some of them. The reputational damage. If you have similar or domain name, they may create the impression of affiliation, association, or endorsement. It would dilute the brand value and brand image. It would have an impact on the exclusivity of the brand, and it would erode consumer trust and confidence. And of course, for any businesses, financial loss is a concern. So if you have a domain name issue in Malaysia, and the first thing you look at would be your courses of action. So in a Malaysian context, you will look at it from Trademarks Act 2019 point of view or common law rights. For Trademark Act, there are two types of trademarks that can be protected when the mark is registered with MYPO. The other one, if the mark is well known. So let's start with a trademark that has been registered with MYPO. And we have two types of infringement. One where it's very straightforward, when a bad actor or the domain name registrant has used a sign that is identical with the registered mark, or used in relation to identical goods or services, and the use is in the course of trade, and of course is without the consent of the trademark owner, right? So if you can establish all these elements, then you are able to establish trademark infringement under Section 54(1) of the Trademarks Act. But not all domain names may be identical. You may have situations where the domain names are similar. And then you have this provision where it allows protection, or it may amount to trademark infringement if the mark is not identical, or if the goods or services are not similar or not identical. So that's a permutation. But for this infringement, the registered proprietor must establish that the use results in a likelihood of confusion on the part of the public, right? So there's additional element that the trademark owner has to prove. So that's for the registered mark. That is assuming your mark has been registered with the MyIPO. For well-known marks have to be well-known in Malaysia, right? So you look at the provision in the Trademarks Act. And if you are able to establish that your mark is well-known in Malaysia, there's no need for the proprietor to prove that it has a business in Malaysia or it has goodwill in Malaysia, right? And it may be able to restrain the registrant of domain name from using identical or similar mark or for identical or similar goods or services. But again, the proprietor of the well-known mark must establish that the use is likely to cause confusion. So there's additional element there. And if it's for any goods or services, right, then the proprietor would need to establish the connection between those goods and services with the proprietor, or the use is likely to damage the interest of the proprietor. So these are the elements. Lastly, we'll look at the common law tort of passing off. So the famous classical trinity that a proprietor would have to prove. And for passing off, the beauty is even if your mark is not registered in Malaysia, right? And if you're able to establish these three elements, you're able to take action based on common law tort of passing off. One, reputation and goodwill in the mark in Malaysia. Two, the action or conduct of the domain name registrant is likely to or has caused misrepresentation. And finally, the owner of the trademark has suffered or is likely to suffer damage or injury. So these are the three elements. So having reviewed the causes of action, let's examine some reported cases in Malaysia that touched on domain name disputes. So Malaysian courts generally have accepted or upheld the rights of trademark proprietors where domain names are concerned. So the first case that we had in Malaysia was the Petronas case. That was in 2003. And then we have a string of other cases as well. And we have a case on competing claims. And the last but not least, the final case that was just decided in September 2023 that Dato' Sundra has touched on earlier on was on jurisdiction issue. So I'll focus on 3 case studies due to time constraint. So the first case is the Petronas case. The brief background basically is no one needs any introduction in Malaysia, especially to Petronas, which is a well-known national petroleum company. So the plaintiffs in this case are Petronas and its marketing arms. It has filed interlocutory proceedings against the defendant that registered Petronas formative domain names, as in all these domain names contain the term Petronas. And it also maintained a website to provide various information, including locality of the plaintiff's service station. So it was decided, without reading the first part. So what is important is the court decided that by registering the said domain names, the defendant has eroded the exclusive goodwill in the name of Petronas, which damages the plaintiffs. The said domain names are instrument of fraud, and any realistic use of them as domain names would result in passing off. So it's very clear. So moving on to the second case, Skyworld. It went all the way up to the federal court. So the brief background of this case is, the plaintiffs, who is the respondent in the federal court appeal, they are in property development business. So they have registered 2 trademarks in Malaysia in class 37, and the representation of the marks can be seen at the top there. So the defendant in the case, they are the appellant in the federal court appeal. They are in the businesses relating to real estate activities, project development, retail sale of construction, and also tourism. So the plaintiffs sued the defendants for various causes of action, including trademark infringement, in respect of the defendant's use of the company names, domain name, skyworldcity.net, and project name. So 3 questions were posed to the federal court, and this is the question that I've extracted here because it's more relevant for our discussion on domain name. So the federal court allowed application for leave to appeal based on the following question of law: whether the use of generic words which form part of a company, corporate, trade, or domain name, which such words are also comprised as part of the registered trademark of another party, but which are not registered as word mark or disclaimed, meaning that the word is not disclaimed in the registration, is deemed to be an infringement of such registered trademark. So perhaps a show of hand, what do you think the answer to this question would be? Is it a yes or is it a no? It's a no, right? So the court actually held in favor of the defendant, which are the appellants in the court, in the appeal. So the salient points that you could extract from this decision is, 1, the plaintiff's marks are registered as composite marks, as you can see from the representation. Skyworld, and then there's a tagline, and then Skyworld with the Chinese characters, not as word marks. So while the defendant's corporate and domain names are orally similar, means phonetically similar or identical, they are visually different. So the court held that you must compare the marks as a whole, globally. And the use of the word Skyworld either wholly in uppercase or lowercase, but not in a mix, uppercase and lowercase in the plaintiff's mark, are considered dissimilar, right? And of course, another point is, look, the High Court judge had made a finding that there's no similarity, there's no likelihood of confusion. The federal court felt that there's no need to disturb that finding, right? So the plaintiffs had failed in their action based on trademark infringement, passing off, and unlawful interference of trade, which is a normal cause of action to throw in when you have other causes of action under IP infringement. So this case kind of demonstrates the competing rights of the parties. And then the last case will be the Thai Red Bull case. So the defendant in this case is a Thai manufacturer of Red Bull beverages. You know that for Red Bull, you have an Austrian manufacturer and then you have a Thai Red Bull manufacturer. The defendant has 13 trademark registrations in Malaysia. And the defendant entered into a joint venture agreement with plaintiffs to produce and sell Red Bull vitamin energy drinks in China, and entered into license agreements for the use of Red Bull marks in China. Without the defendant's consent, the first plaintiff, who is an employee of the second plaintiff, acquired registrations of 11 domain names, all containing the term Red Bull, right, from a Malaysian entity, Webnick, pursuant to a registration agreement. So the defendant took action against the plaintiffs in China, and on appeal to China's Supreme Court, the decision was upheld that the defendant was the rightful and legal owner of the Red Bull trademarks in China. And subsequently, the defendant filed a UDRP proceedings with WIPO, and they managed to get the domain names transferred to them, right? But plaintiffs were not happy, so they filed an action in the High Court in Malaysia. So the cause of action was premised on the fact that the filing of the WIPO complaint by the defendant was itself an unlawful interference with the plaintiff's trade. And the plaintiffs have sought for various declarations, including an order to set aside the WIPO panel's decision. So defendant counterclaim for passing off unlawful interference with trade and abuse of legal process. But I will not go too much into the counterclaims. So what is interesting from this decision is that the Malaysian court said or held that it had no jurisdiction to hear or adjudicate the WIPO decision. It was not the court's function to act as a judicial review or appellate body of any decision made under the UDRP scheme. The court went on to say that it could not interfere with or second-guess WIPO panel's findings and decision, which were based on those facts. So the filing of the defendant's action to protect legal rights cannot be said to be interfering with the plaintiff's trade. So the plaintiff's filing of this action constituted an abuse of process. Yeah, and the court was quite strong in the language in criticizing the plaintiffs. And it stated that by adducing an agreement that purportedly granted the second plaintiff, an exclusive right to manufacture and sell Red Bull drinks in China, the authenticity of which was doubted by both the China Supreme Court and WIPO, constituted a serious and grave abuse of court proceedings. And it awarded general damages of 200,000, and in addition awarded 300,000 as exemplary damages to demonstrate the court's displeasure of the plaintiff's abuse of process. It's a very interesting case. So coming to my final slide, I have 2 minutes and 38 seconds, which will make Bahari very happy. So what are the key takeaways? Yeah, just in case you don't remember anything I said. I think the key takeaways from all these decisions basically are you need to protect your IP rights, right? And if you've seen the instructive guidelines from Skyworld, if you have a composite mark, and if your domain name, domain name, of course, is a word mark, you should file and register the word mark separately, because otherwise you may get into the issue that the plaintiffs encountered in the Skyworld case, because if it's part of the composite mark, it's not confusingly similar. So that's one, protecting your trademarks. And of course, for the right goods and services. Secondly, it is important for monitoring, vigilant monitoring, because if you don't monitor and enforce your rights may be diluted, or you may end up losing it entirely. So early detection, like smoke detector, right, is very important. Intel gathering, you may have to engage private investigators to gather information about the nature of the registrant's business, maybe to establish bad faith registration. And it is important to educate stakeholders Why? Because if you look at most organizations, the domain name registrations are not parked under the legal department, right? They are normally parked under the IT departments. And the IT department may not conduct prior clearance searches, may not do any due diligence before they register a domain name, not knowing that the registration of the domain name itself may not give them the rights. It is important to keep records, especially if you want to rely on common law torts of passing off, as well as your well-known marks, right? So you need to make sure that you have proper records of your enforcement activities. And if you notice that a lot of times when you receive cease and desist letters on behalf of your clients, there's always a provision where the acknowledgement of intellectual property rights. Sometimes it's very obvious, but the reason why the trademark owners do that is because they want to collect, a signed undertaking acknowledging that their rights are well known. So that will definitely help them when they enforce their rights in the future. So documentation is key. When you have all this intel, you need to explore options and the enforcement strategies. And of course, dispute resolution through ADNDRC provides you with the most cost-efficient mechanism, shorter time, right? And that's very important. But of course, you need to fit in within the bad faith registration aspect. Yeah. With that, thank you very much.
Thank you very much, Jenny. There are some questions that came in, so I'll reserve it towards the end. Ellen, just hold your breath a little. We'll address the questions at the conclusion. James, I know the clock has started ticking. James is going to talk about the fire. I like the way you define fire.
His Excellency Professor Dr. Ahmad Mohammed, His Excellency Professor Dato Sundara Raju, excellent management team of AIAC, my dear colleagues, friends, and virtual partners of ADNDRC community attending today from their own comfort zones. A very good morning. I'm grateful to Professor Dato Sundara Raju and AIAC to give me this opportunity to share my views on this very interesting topic, which I take from my paper published very recently in the Journal of World Trade. And the topic is also just nice. It fits into the same context. And I will take the cue from my colleague, Ginny. Protect your own IP rights. Cease and desist. So what do we do? How to define infringement? In a borderless world of e-commerce and open AI online marketplaces, IP rights are personal rights. So we have a trilogy of domain name and brand trademark. Which one is registered? Should I protect myself or should I rely on the state to protect my IP rights? It's not a public property. Intellectual property is a personal property. So we have a challenge here. And that's where Ginny just left that policing, monitoring your own website, monitoring your own IP trademarks or other IP rights. UDRP is a smoke detector. It's a very good, effective solution. And thank you. Yeah, no, it's okay. It's moved on by itself, but I was still on the first slide. Does it work? Yes, it works now. Now it works. Thank you. Without him, I can't start actually. There are honest infringers. I know there are some dubious words I'm using. Infringers, in someone's perspective, but honest in someone else's perspective. They're both sides of the same coin. And there are tough contenders, and cyber squatting, I think by the end of my slide, you will see cyber squatting is the right word, or domain investment is the right word. There are known infringing domains, what to do with that, but they're doing business of IPR infringing products. What's the role of ADNDRC? What's the role of WIPO? And what's the role of DNDRCs, Domain Name Dispute Resolution Centers? And finally, we come to the fire. So looking at the statistics, if you look at it from the year 2000 till date, out of 53,460 cases which were registered with WIPO, excluding those registered with regional DNDRCs, almost 90% were ordered to be transferred to the complainants, the rights holders. Only 1.52% were cancelled, and 8.81% complaints were denied. And the trend is similar even in the recent years. So what do we get from these statistics? Is the UDRP working against infringements? Is infringement protected? IP rights are protected? I think story is different. Can the transfer of a domain name stop infringement? Definitely not. Infringement still goes on. Domain name dispute resolution is only for domain name. So what about the IP right owner? They still have to pursue from other forums to stop the infringement. So point one, domain name protection is just the first step. It's a smoke detector of bigger infringements taking place. So start with the smoke detector, move on to the next stage and see what's happening. Now, what is in the domain? Is it a brand name being used, or is it a trademark, or is it a company name, or is it a product name? There's a confusion. Registration is through a contract. There is a freedom of contract between the applicant who registers a domain and the registrar who registers the domain for the applicant by paying a fee. Unlike intellectual property rights, which are territorial, domain name rights are by contract. They're universal, they're worldwide. So how do you protect? You can protect your trademark. You can contest against the domain name in that country. What about the other countries? So moving on to domain names, they have an effective right to use them anywhere and all over the world. A smoke signal which comes is a third party registering a domain name that is either confusingly similar or incorporates a trademark in a domain name without authorization or a license from the trademark owner. Is that an infringement? That's a willful infringer. And intellectual property rights of the trademark owner are infringed. What about the products and the services? That's a tough question that cannot be answered by domain name registration and domain name cancellation. So let us start with the protection. It's not automatic protection. So you need to do the policing. And you can complain as a owner of the particular trademark, can go for domain name dispute resolution system, ADNDRC, WIPO, DNDRC, or before that, you can contact the domain registrars, get the details of the infringer, and send a cease and desist letter. Maybe an honest infringer will realize his mistakes and will change. Or maybe a waiting infringer is waiting for you to approach him so that you can pay him and buy back your domain. Or you go to the national courts, state agencies, or IP offices, or arbitration, mediation departments, or tribunals, or get orders for stopping the infringing products from being imported or exported. And if it is a domain which is giving some comments which causes anti-competitive behavior, then can go to the competition commissions and pursue your case if by domain alone it cannot be pursued. Now, how does UDRP help? As I just mentioned, sorry, it's not the correct one. Yeah. How does the UDRP help? A smoke detector for a particular location, or is it a global smoke detection system? There's an infringing trademark in a single domain. There were 1,000 trademark infringement domain names which have been registered with WIPO since year 2000, and they were well known and they were reputed. Nobody infringes or nobody copies the domain which is least known or unknown. They only go for the big names because they're popular and that's the benefit they get. Now, I share with you one simple case first. A case of Nadobel and Mr. David. Nadobel is a company which has operations in 15 countries and has a turnover of about 418 million euro. It sells nutrition and Sante, and they developed the trademark ISO Star. And they had a domain isostarshop.com, which was not renewed in August 2022. A Frenchman, Mr. David, went and registered and started selling similar products, isostar.com. So that's a case of a single domain, single infringer. Nadobel complained under the UDRP and successfully managed to get it transferred. What's the point here? Yes, they get it transferred. Who paid the cost? Nadobel, the complainant, paid the legal cost and the UDRP cost. This website was for sale at 7,000 euro. When the complaint was lodged, the price reduced to 1,500 euro. But at the cost of 1,500 USD for the domain name dispute resolution procedure and the legal cost, Nadobel managed to get the website back. So should they have gone to the infringer or the copycat who copied this web domain and registered and get it back in 1,500 euro? That would have been cheaper. Well, that is the question. I leave it for the audience to think about. Let's look into a domain names, which is multiple domain names and registered by one entity. Now, multiple domain names, multiple applications. Reebok, I think everybody in this room is familiar. What is Reebok? And a Malaysian company, Client Care Web Commerce Communications Limited, Malaysia. There were 4 disputed domain names containing the well-known trademark Reebok. Malaysian company used a Singaporean registrar, Alibaba.com, and registered a domain called Colombia, Reebok.com, Reebok Costa Rica, Reebok Ecuador, and Reebok Panama.com, and selling counterfeit products, same like Reebok. It's not only confusingly similar, it sounds very authentic, very genuine, and selling similar products in countries far away from the original, the owner of these 4 domains. Now, interesting point to note is that even though Reebok is well known, still it was allowed to be registered by an unknown party from a remote place into remote countries. So there is this called borderless world we live in. Of course, after the case, they were able to get it back, but at what cost? There's no cost incurred by the respondent, because respondent doesn't have to pay anything if they don't contest the case. All the cost is paid by the complainant. So international registration of trademarks alone does not provide a secure fence against would-be infringers. We can have international trademark registration, but we still have to do our own policing, our own monitoring. Then we go to honest infringers. There is a company, I believe quite a number of you will be familiar, AP Moller. They have operations in 130 countries, and their trademark is NeoNav, N-E-O-N-A-V. Another company, Logistic, they started a website, NeoNav. And then if you go to the NeoNav, it will take you to another website, Logfreight. And on that website, you can place orders for logistic services. And they also purchased one more website from a domain name seller website. And that become the second so-called brand bucket. They sell the branded domains. So brandbucket.com. Now they contested, but passively. Again, that was taken back. And
Snatching the mic from you, just trying to see whether I can.
yeah, thank you. Thank you. I got worried that my mic is being taken away. I think it's moving by itself. Yeah. I'm not speaking in the same speed as the slides are moving. Yeah, okay, good. Thank you. So in this case, again, the point is the costs were incurred only by the complainant, even though the respondent contested, but they didn't pay any fee. And after that, they did not follow it through, and it was transferred back to AP Moller. Now, again, another big company. Now, most interesting case comes in here, a single controlling infringer of a well-known trademark and products through multiple domains in multiple countries, multiple jurisdictions. This is a case of 56 domains. And the issue involved 11 individuals having registered domains across 7 countries, but controlled by one single individual, selling goods and disrupting businesses under the brand name Longchamp. Now, this again shows the magnitude of infringement through domain names, 56 domains. How difficult it is for the Longchamp, the trademark, and the business operator to manage and police against all this. Do we have a solution under UDRP? Unfortunately not. They have to go through the process. But fortunately, the UDRP gives a first stop. Immediately, the domains are transferred back after the case is filed and the tribunal or the administrative panel gives the decision. What happens? The website of the infringers is transferred. That means the business of the infringer or the copycat domain owner is stopped overnight. And that's the beauty of the UDRP. Their business is stopped. They are out of business overnight, even though they were enjoying a thriving business by using other people's reputed marks, but their business is totally shut down overnight. No court order into 11 jurisdictions, into different countries, going through the legal process would have achieved this kind of an effective enforcement order as it is by the transfer of the website. This is the most beautiful part of UDRP. So earlier, maybe I painted a picture that the trademark owners are pitiful because they cannot protect, but now you see the impact as we go along more complex cases. Now, just to add a little bit more climax, we have a case of very interesting case coming up. I'm going to talk about that one. Non-infringing domains with IP infringing products. shopping malls, online shopping, online platforms, social networks or Facebooks. All these are not infringing any domain, but they are selling products. Now, infringing trademarks, not products or domain names, in online shopping platforms like Amazon, eBay, Lazada, or Carousel. Now, these are very difficult to control. They don't fall under the purview of domain name dispute resolution. I will just give a brief example of this case of Calvin Klein and HS International. In this, the website one website promotes genuine products. When the buyer places the order is placed to another website in China. And then when the shipment order is placed, the shipment is by the courier, a legitimate business, and then it is imported back to Singapore. So HS International is a courier company, legitimate business. They claim that they are only a courier. They are not selling Calvin Klein products. But their website displays all the branded products, not only Calvin Klein. So this case was very interesting. It went through the process. Ultimately, what's the outcome? Outcome because of the Calvin Klein products and the trademark registered. This was a dubious chain of bypassing the IP rights and infringing it. So it has to be shut down. It has to be stopped. When it stopped, whole business of HS International collapsed. So playing with the trademarks, playing with the IP rights is a dangerous game. It's not profitable for the long run. It's for a quick buck fast, maybe. And that too, the cost is borne. In this case, the cost is borne by both parties. Of course, the winner gets the full cost afterwards, and that led to the closure of HS International, which is now closed. It's no longer in business. The next case, I'm going to talk about legitimately registered domain names before registration of a trademark. Grab. How many of you don't know Grab? Anyone don't know Grab? Then you must have heard the case of Grab. Before Grab was registered as Grab, someone registered the Grab trademark. Not trademark, Grab domain name. And this is a failed attempt. And they tried to sell 4 domains to Grab at $250,000 each, $1 million sale. And the sale didn't go through, so it collapsed. And my time is running up, so I will have to leave this case with you to give you a short snapshot. 3 corporate services. Maybe you can move to the next slide, please. And the next one. So finally, the Grab didn't buy. They were about to buy, but they didn't buy. Then who is suing Grab? The seller of the domain name is suing Grab. This is a very classic case. It's not the infringer. The complainant is suing after the infringer. Now the question arises, how this happened, how this goes about. So maybe I will quickly come to the next one. Yeah, okay. So what is FIRE? Find, inform, respond, and extinguish. That's FIRE. FIRE is not the fire you see, but you must find first where it is. So you have to get from customer feedback or internal web monitoring teams or AI models. Inform who? Cease and desist notice is the first thing. And then domain registrars or ADNDRCs. Respond, consult ADNDRC or engage lawyers or contact trademark attorneys. And then give public notices, self-extinguish, and strategize action plan. So there are lots of cases which you will find that it is getting more and more difficult to protect your IP rights by domain name alone. You have to have a complex set of tools and strategies to manage. Please, next one. Yeah. So there is some substantive issues which are evolving as we are going through new cases and the new world. Grab is a unicorn company, and the company who is suing Grab for not going through the purchase of 4 domains at $1 million cost has 1,232 domains registered under the names of the family. and they have no intention to use the domains. Now the question is it wrong? Is it unethical? They claim that this is investment. It's not cyber squatting. They invest into the website, they register a domain, and then they put it up for sale. So it's like buying a stock in the market and then selling the stock later on. So where is the freedom of contract? Where is the freedom of speech if this is called cyber squatting and this is called bad faith or illegal? Now we have to answer these questions. Not easy to answer. So when is the intention to make profit bad faith? They have an intention to make profit. There's no secret about it. Why they registered 1,200, they invested money is to make money. So we have to rely on anti-competition laws or priority of trademarks. So we have lots of challenges ahead. And these are online marketplaces, online unregulated, regulated marketplaces and unregulated marketplaces. We have counterfeits, which are genuine. They are not counterfeits like counterfeits in the old days. They are genuine counterfeits. And spams, scams, shams, freedom of speech. So these are some of the issues coming up. What ICANN has come up recently with one very good point, but it is just a smoke detector. You can register in your trademark with the TMCH, Trademark Clearing House, and whenever somebody registers a domain name similar to your trademark, you will get an alert. So that means you will get a smoke alarm. That's all. After that, as the owner of the IP right, you will have to take action. So in conclusion, ADNDRCs are the most cost-effective and efficient first step in curbing infringement of trademarks. Number two, in the present borderless digital world, domain name is the most precious asset. It is not buy cheap, name cheap, or ready, what is something like Ready Go, something like those websites you buy in $20. It's not that simple. It's very, very expensive, and that's your lifelong asset. Thank you very much for your attention.
No, no. Thanks very much, James. One of the things you said just now, where you pose the questions, when there's a problem, what do we do with it? But I particularly like the suggestions, go and find lawyers. So please find lawyers when there's problems. Okay, now next, Leslie, the stage is yours. And yes, so she's going to bring us to the future. And let's see what has Web3 got to offer and what's the future outlook. We are looking at the new way to put out the fire or extinguishing the fire. Thank you.
Good morning, ladies and gentlemen. Thank you for having me here today as part of the panel for the first session. I'll be exploring infringement in Web3 domains. If I could get my slides on the screen, that would be great. And we can jump right into it. Nope. Too much into the future already. Okay, it's okay. I'll just kick off. I'll be covering the 4 top points. The first one, we'll just be exploring Web3 and what it means to have this potential new system for web naming. I'll jump into trademark infringement in Web3 domains, enforcement of DNDR in Web3 domains, as well as my last point will be future outlook and a new way to put out the fire. So apparently tech has said on the screen that there's an issue with my slides, which is quite unfortunate because I was very keen to show the first few. Is this something that can be fixed in the next 30 seconds? No? Okay, no worries. So I'll start. With Web3, some of us may be wondering what is Web3. And in order to understand Web3, I think we need to go back a little bit into history and understand the evolution of the internet. Whereby in the early days of the internet, we used to have Web 1.0, And this was known as a read-only web. Those of us that may recall in the early or mid 1990s, websites were very static. We used them mostly for browsing and retrieving information. And you may recall we used to use this browser called IE and Netscape Navigator, the one with the very big N. I had it on my slide, so it's unfortunate we can't see that. Bring back some memories. We used to use search engines like MSN and Yahoo before Google became a dictionary word of itself. So if we think back on those days, there's basically no user-generated content, and interaction on the internet was actually very limited. So this is 1990s. Moving forward 10 years later, in the mid-20s, we had Web 2.0, and this brought about interactive, social media-driven websites, very much like the world that we live in today. We know Facebook, Twitter, now known as X, allows for greater communication and collaboration. We communicate with each other online. We have websites like Wikipedia and YouTube, where it's focused on user-generated content. We have e-commerce platforms like covered by my learned friend earlier, Amazon and eBay, or the Malaysian version, Lazada and Shopee, which enables online shopping. And this has allowed us to purchase goods and services from anywhere across the world. But there's a downside to it, because all these big tech organizations basically control our data, and they provide us the services by using our data. And as the famous saying goes, if the service is free, basically we are the product. And what these institutions are doing, they have their service or their tech, they combine that with AI, and they use that to know us better so that they can sell us better advertisements. Now, what then is Web 3.0? So Web 3.0 is basically a decentralized web. It enables peer-to-peer network where users can basically interact directly with one another without that intermediary. Many have said that Web3 is the future of the internet. And actually, at this very moment, there's no specific definition of what 3.0 is, but we know that it is related to the semantic web, and that really the objective is to democratize the digital environment, to take away all those big tech guys. There are 4 key aspects of Web3. The first one is decentralization. And decentralization basically means that all the data is not kept in one general server. It's basically kept in several locations simultaneously. The second aspect, it is trustful and permissionless. It basically allows us to interact and access data, again, without that intermediary, those big tech companies who now keep our data. The third point is artificial intelligence and machine learning. So with this, the computers will start to understand humans a little bit better. And in future, this will ease our internet browsing. And the fourth one, connectivity and ubiquity. The internet will basically be accessible to everyone, anywhere, anytime. And as time goes on, we are starting to see the advent of new smart devices to navigate the web. Okay, great, let's get this going. So Web 1.0, they're the famous Netscape Navigator logo. I'm sure that brings back memories. Then, very familiar, all of us probably have 90% of those logos on our phone today. And where we are on Web 3.0, these are the 4 key aspects which I covered. And really, when we look at these 4 aspects, Web 3.0 is really about ownership, it's about community empowerment and complete transparency. So with Web 3.0, we see the famous Bitcoin and Ethereum logos there on the top together with Coinbase, and the one with the lion and the other logos. These are Web3 alternatives. So for web browsing, instead of using Google Chrome, you could use Brave, that lion logo. For search engines, instead of Google, there's Presearch, the blue one on the right. For music streaming, instead of Spotify, there's Audios. Professional network, instead of LinkedIn, we could be looking at Indoors. And what are Web3 domains? Web3 domains are basically the next phase of the evolution of the internet. Again, remember the aspects? Decentralization, ubiquity, but all of this is still in the development phase. And it's marked by cryptocurrencies, NFTs, like the famous Bored Ape over there on the right-hand side. It's a collaboration with Adidas. And the decentralized blockchain system is basically going to change the way information is stored, the way it's shared and owned over the internet. So how does all this work? Unlike Web 2, where centralized servers are at the core and owned by all these big tech companies, Web3 scatters its data across the internet, empowering users at the expense of potential misuse. There's always room for abuse. And Web3 domains are registered into registries that maintain the list of domains. And there I have some examples of Web3 TLDs, like for Ethereum wallets, you will see the extension .eth. For Bitcoin, you'll see .bitcoin, .crypto, or .nft. Now, Web3 domains can serve various purposes. It can facilitate cryptocurrency transactions. You can link them to our crypto wallets for payments. You can store digital assets like cryptocurrencies and NFTs. These will be used to organize our digital assets. It can act as a unique identifier in the metaverse. And this is where it could potentially function as a username for easy identification. So there's an example over there at the bottom. This is crypto-gucci.eth. And they use that username on their, last time I used to call it Twitter, now it's X profile. And what could potentially happen in the future is that their profile picture could potentially, they could put their NFT there if they subscribe to the premium account on X. So these are what we could potentially see in the very, very near future. Now, what are some of the benefits of Web3 domains? Under Web 2, we pay a fee, and basically the domains are leased to the users for a specific period of time that results in recurring payments. Whereas on Web3, domain purchases upon one-time purchase fee are granted exclusive ownership. Web 2 is usually domain names are used as the website's identity, whereas with Web3, there's much greater room that will allow for more than just website building. You can, as I said earlier, link them to your crypto wallet, etc. Now, there are several domain naming services that are existing in our world today. Famous ones, Unstoppable Domains, ENS, Ethereum Name Service, Blockstack, and Gateway. So as I mentioned earlier, when the domain owner purchases it, it basically, they own it for life from there on. So here are just some very key differences between a DNS, a traditional domain name system, and an ENS. So in a DNS, we're very familiar, it's managed by ICANN. Whereas under ENS, we have the ENS DAO, and that stands for Decentralized Autonomous Organization. It's basically a member-owned system without a centralized leadership. Remember, everything is about decentralization. In a DNS system, it's basically to link the device IP address to domain name. Ginny was saying about how this is human-readable words instead of a bunch of numbers. In ENS, as we said earlier, you can link it to the wallet. As you see on the right-hand side, many, many more applications that can be put in an ENS system. Here are some more differences. ENS will rely on the smart contracts. Very important, the middle one. In a DNS system, it's possible to force a domain takeover, whereas it's not possible in an ENS system unless the smart contract is changed or the owner is willing to give up his token. I spoke about the fees earlier, and also relevant to us today, what are the measures to protect the right holders? So in a DNS, we have well-established systems under ICANN system, whereas under ENS, of course, as we say, is still developing, still evolving, and the measures at this moment are still in the developmental phase, and perhaps we'll be seeing more of it in time to come. I'll go to my second point, infringement in the Web3 domain. Now, the emergence of blockchain domain names gives rise to what we call cyber squatting 2.0. My learned friends spoke about cyber squatting 2.0, and basically similar. Cyber squatting is still very much the same, but it happens in the blockchain domain names. And token contracts include a self-executing software code. And this makes ownership of the domain immutable, it's unchanging over time, and it cannot change unless the owner is willing to give up that token. There are no intermediaries which can arbitrate. And I mentioned earlier, only the wallet owner and controls full ownership. It's executed in the token. Okay. Now, I'll move on to name collisions. So sometime last year, there was a discussion at ICANN about blockchain-based domains. And the concern that was discussed is that the lack of namespace coordination between that alternate naming system and our traditional DNS, and how this might actually result in what we call name collision. And so ICANN's definition is there over there. Basically, it's a situation where a name that is defined and used in one namespace also appears in another. Now, to illustrate this, we have this case study. If you remember just now, the naming services provider, we named a few, and this was the battle between two companies, between Unstoppable Domains and Gateway. And this was over the domain name .wallet. Okay. Unstoppable Domains had been managing that .wallet since 2021, and they had in fact sold hundreds and thousands of domain names based on .wallet. Gateway, on the other hand, started selling it a year later in 2022. And so what Unstoppable Domains did, they sent a cease and desist letter to Gateway, demanding that they stop selling that domain. But as we all know, because the blockchain network is decentralized, this means that no single person actually owns or controls any part of the network. But what was the key difference in this case, or the game changer, is that Unstoppable Domains had actually filed a .wallet trademark with the US Patent and Trademark Office, and they basically submitted a lawsuit against Gateway for trademark infringement. And upon the filing of the suit, for some reason, Gateway, well, in other words, sort of shut down their business. They stopped accepting registrations. Their business stopped. And even though Unstoppable Domains won the battle by shutting down their competition, it's still a somewhat unstable position, because that trademark application that they had for .wallet was an intent to use trademark application. And the sort of danger moving forward is that USPTO does not grant trademarks for top level domains. Okay. Moving on to enforcement. Now, one of the most critical legal implications of blockchain, and we spoke about it earlier, is how do we protect the brand owner's rights? And for enforcement of DNDR in the Web3 domains, this is probably going to need to rely on decentralized, again, governance mechanisms and the smart contracts. Now, blockchain domains are not recognized by ICANN, because they're not part of the DNS hierarchy. And this basically means that any standard UDRP dispute may fail for lack of jurisdiction if the dispute revolves around a blockchain domain names, maybe. Now, unlike the traditional system, which is governed by ICANN, what Web3 domains may be able to do is they may be able to employ the DAOs, or decentralized arbitration systems, built on blockchain. Now let's look at DNDR enforcement under ENS, one of the naming services provider. And although ENS doesn't limit anyone on what they can do with their .eth names, certain technical measures have been put in place to protect trademark owners against cyber squatters. And these are steps like they put in a 3-step process for registration. Perhaps the registration fee may be prohibitive. Expired names need to go to the premium account after a certain period. And the ENS system thrives very much on altruism, where the domain owner may give up their domain name if they feel it's sort of for the betterment of the system, or this is the rightful owner. So that's that sense of altruism in there. But I think you would agree with me that these mechanisms are not very ideal. Let's compare them with the other service provider, Unstoppable Domains. Now, Unstoppable Domains has developed a protected brands policy. Many of us will be familiar with the sunrise period that exists under the ICANN system. Unstoppable Domains guarantees protection of trademarks registered with USPTO. They provide that sunrise period. Under the terms of use, when one signs with Unstoppable Domains, there are several points in there. You cannot violate or infringe other rights. Unstoppable Domains may refuse to sell at their discretion. And the service also reserves the right to cancel domains purchased with a full refund. Now, this one probably is the most interesting one. Unstoppable Domains has a protected domains service. And this basically means certain domains are protected if it is associated with a particular brand, organization, or notable person. Here's an example. I did the latest search because, maybe one day I want to own apple.crypto or apple.eth. This is the latest search. And you see at the top, apple.crypto has the word protected with the phrase, protected domains may be reserved for brands, notable individuals, and trademark owners. If you would like to purchase, please fill out this form. And the list even goes on to show apple.x, apple.nft, .wallet, .polygon, .unstoppable, .dao, .blockchain. These are all protected under Unstoppable Domains system. Apple.com is already taken. Apple.eth is also taken already. So in general, currently, comprehensive legal frameworks specifically governing the Web3 domains are still under development. None of the internet-related regulatory bodies have authority over these blockchain domains. And really, the regulation lies within the system or the blockchain entity itself, as the two examples we saw with ENS and Unstoppable Domains. My last talk point. The future outlook. We've seen the smokes, and now let's think, how can we put out the fire? 3 points from here. First one, to protect our brand from Web3 cyber or token squatting. The possible ways are forced compliance using leverage in terms of practical, financial, or legal leverage. Perhaps maybe some court judgment can be used to preclude cyber squatters from using the best features in blockchain. So we're talking metaverse exchanges, decentralized apps, or maybe somehow from the business perspective, we can make it harder for them to sell the Web3 domains in the name of profit. Now, identifying an infringer, how to spot the smoke. In Web3, although the blockchain owner's domain owner's name is anonymous, cryptocurrency and NFT transfers do still go through the system. This makes it visible and traceable. That could be one way to identify and spot the smoke. Find an account on the centralized exchange where the crypto was bought, trace it from there, perhaps get a court subpoena, and maybe some other traces such as the owner had showed his wallet address on some other platform. Not very straightforward, but still an option potentially. Lastly, a new way to put out the fire now. Lawyers can come into the picture, and really it boils down to all of us in this room. We perhaps need to come up with more creative ways or enforcement strategies as technology continues to evolve daily. Okay. Another option is in the smart contract to include an option for a forced domain takeover. There could potentially be enforcement via IP laws. Lastly, utilize the benefit of Web3 because of the decentralized system. Every transaction is actually recorded and available to the public on that public ledger. That could be one way because that transparency doesn't exist in Web2. So in closing, my last point, I think Web3 holds a lot of promise and potential, especially from the regulatory and governance point of view. But we know for sure this looks to transform the way that we interact, that we transact, and the way that we own content. And we're not just talking about one industry per se. We're looking at content, art, gaming, digital assets, all this across the internet. And are we at a point where we're looking perhaps a shift from a centralized system to a decentralized system? But since Web3 is still in its early days, we expect challenges to arise, scalability, usability, and as I mentioned, regulatory considerations. Happy to take questions later. Thank you very much for your time.
Sorry, I need to get some help from this. I don't know what I did. There were some questions that was. Yeah. Okay. Thanks very much, Leslie, for the last presentation, and also to remind us. I mean, if you remember back in the days when we signed on to, before we get on to the email, you got to sign on to the server, and then oh gosh, now it's just within the fingertips, but the danger is everything we know, everything we do, and everything we search, I mean, whether it's a nice thing or the not nice thing, for the next 1 month or so, recently, or not recently, I purchased some product. Okay, it's not nasty product, but it's normal product. But when you do a search, ultimately, a couple of months later, all those related or unrelated nearing to those kind of products will come up your search, and then your kids look at it and say, oh wow, why are you looking at all these pictures? So that's a danger where you're being monitored. Okay, I was told that we have only 5 minutes. I know we are standing between the next session speakers. They're all looking at us angrily, and also to all of you, we are standing before the lunch. I'm just going to ask some question that was raised. The first question was put by Alan. Alan, if you don't mind, I will just modify a bit of your question because I think it's a bit sensitive to read out exactly your question. But Ginny, this is to you. Some registrars, should the registrar be allowed to accept domain name registration which they know are identical or confusingly similar to famous trademarks not owned by the registrant?
In an ideal world, the answer would be yes, right? But the sheer volume of the registration of the domain names is impossible for any registrar to sieve or filter or to conduct any reference checks with IP officers, and bearing in mind that IP officers are territorial in nature. So I don't think that is possible unless ICANN would adopt a different position. But if you look at what ICANN is doing, I think they're trying. They've created this trademark clearinghouse and all that. They're trying to kind of like adjust and consider the rights of trademark owners.
Ginny, in case where a business identifies a potential domain name dispute, what enforcement strategies are most effective in protecting their brand?
Well, it depends on, of course, if it falls within the UDRP rules, like if it's a bad faith registration, the UDRP proceedings would be the best because it's the fastest, it's the most cost efficient. But not all domain name disputes or registration would fall within that, like what we have seen in the Malaysian cases. Some of them are merely competing business claims, right? Because as we know, there are no two identical domain names, and you have businesses dealing with different business industries may want to adopt the same name. So essentially, you need to assess the nature of the use to identify whether is it purely a bad faith registration. If it's not, whether you have a right in terms of the framework within the regime, whether it's trademarks in the particular country or it depends on the countries where the action is committed.
Thank you. Thank you, Ginny. James, these two questions are for you. Okay, the first one is from an anonymous attendee. Some companies or entities do not maintain a website, but they use a Facebook page to maintain their digital presence and sell their products and services. So the questions to you is, does the branded Facebook page come under the purview of domain name, and therefore in case of infringement is actionable as a domain name dispute?
Thank you. This is the question which I highlighted in one of the slides very fast. Unregulated marketplaces or unregulated shopping places. Facebook or social media putting a brand of someone else and trying to market products is a direct infringement but it is not a domain name which is registered on the website of the Facebook. So Facebook has to be approached by the owner of that particular brand name or the trademark, which is being used by someone else without license, selling on the Facebook. So Facebook may, after reviewing the evidence provided by the complainant, remove that advertisement or remove that page. That's all they can do, because domain name registration is a contract between a registrar, which has a clause that in case of any dispute, it will be referred to UDRP procedure. So in this case, there is no clause and it is not a domain name. It is just a Facebook page. So it does not apply.
Thank you. There's also another question. Almudena, sorry if I pronounce your name wrongly. Now, what would be the advantages of requesting the infringing domain name to be transferred instead of cancelled in a domain name proceeding if the trademark owner already has a domain name?
Yeah, that's very interesting. Why should 156 domains or 1200 domains to be transferred? It's not just one domain and then pay the annual renewal fee. Now, this is a question of taking the cost of risk management. If you just cancel, how do you stop someone else registering again with the same name? They pop up again and again and again. So they try to get it transferred. Two benefits. Number one, all the business, if they were doing under that wrongfully registered domain name, that will be automatically transferred to them. So they get new customers, new links, and new database. So that's the first benefit. Second, they will be able to stop more similar domains coming up because they already transferred it. So it's a cost, yes. Renewal cost is there, yes. But you get the first benefit is the database, the customer, and the business. So that was the case. I could not talk about 188bet.com. They transferred some 162 domains, and with that come all the gaming customers to the original company, which was a trademark owner, operator of betting company in UK. So I think that's a good example.
Isra is scolding me now. But to be fair, can I just ask from Leslie a question? Now, given, all of us likes to speak to someone. Okay, in the recent years when, when you go to a certain website, when you have a problem, they lead you to a digital, you speak to the machine. And then when you type some normal language, you will say, sorry, your questions is not within our purview. So, we still like human. A dinosaur like me still like to talk to human. So my questions to you is that given the decentralized nature of Web3, right, how contactable are the Web3 domain naming services? If a trademark owner wants to get in touch with them on the infringement issue, what can the trademark owner do?
Let's see. I'll go back to the two main naming services provided in my slides just now. So for unstoppable domains, I think they have forms on their website. I think they've even provided for infringement situations where they have like a legal email that you can actually email to. And Unstoppable Domains is an incorporated company. So at the end of the day, I suppose there is still a legal entity to return to, notwithstanding that they operate in the decentralized system. In comparison, ENS is run by or managed by one of the DAOs, whose sort of human or brick and mortar body is a foundation currently based in the Cayman Islands. And there is not many forms or emails that are available that make them directly contactable. I think these are some of the issues that have been brought up on forums. We've even been asked these questions before. There's a suggestion that you can actually contact the Ethereum team on their respective individual emails, or they encourage you to contact them through Discord, which is another app. So I suppose depending on which service provider you choose to go to, this is something worth considering. How contactable are they actually? Yeah. Thank you, Bahari.
Thank you very much. Thank you, Jeannie. Thank you, James. And thank you, Leslie. We better get off the stage before someone throws chairs at us. Thank you very much, everyone.
Thank you to our panel speakers and our moderator. Could you please remain on stage for a short moment? We'd like to invite the chairman of the AIAC's advisory board, Professor Dr. Rahmat bin Mohammed, on stage to provide a token of appreciation to our panelists. Ladies and gentlemen, please give a round of applause for our first session. Thank you. Thank you very much to our first session speakers. Very excellently moderated by Mr. Bahari, and to Leslie, we apologize for your the delay on your slides. Trying to be very tech-based here, we are. Without further ado, we move on to the second session of our ADNDRC Annual Conference 2023. This session will hear directly from the representatives of the various ADNDRC offices on procedures and best practices. With that, I'd like to call upon our moderator, AIAC's very own Ms. Priscilla John, on stage to moderate the session. Joining her on stage are Mr. Eric Ng of HKIC, Mr. Yoon Ge Song of KidRec, and joining us virtually is Ms. Hang Min of CTEC China. Ladies and gentlemen, please welcome your panelists on stage. Thank you.
Thank you, Ezra. A very good afternoon, everyone. And to those of us joining us virtually, depending on where you're tuning in from, a very warm virtual welcome to you. And we hope you're keeping well and safe. Now, today, as we embark on this interesting conversation on ADNDRC practices and procedures, let us set the tone for an open and constructive discussion. Our aim for today is to have various perspectives being shared, explore our respective insights from the case manager's perspective, as well as ultimately gain a deeper understanding on the ADNDRC's procedures and best practices. Together with me today, we've got three experts in the industry who will be sharing their perspective and experiences in handling a UDRP matter. Now, before I start the session, I would like to start by introducing our first speaker, Mr. Eric. Eric Ng is the Deputy Secretary General of HKIC and heads the ADNDRC Secretariat in Hong Kong. Prior to his time at the HKIC, Eric was a barrister at law in Hong Kong, specializing in international and commercial and construction arbitration. Joining us virtually today, we have Ms. Hang Min. Hang Min is a case manager from China International Economic and Trade Arbitration Commission, also commonly known as CTEC. She has been engaged in commercial arbitration and alternative dispute resolution for more than 8 years. And last but not least, we've got Yoon Sang from KISA. Yoon has received a master's degree in computer science from Yonsei University in Korea. Yoon has been with the Korea Internet and Security Agency KISA since 1999 and has been engaged in matters relating to cybersecurity assurance, computer incident response, and cryptography. Since 2022, Yoon has been serving as the Secretary General of the Internet Address Dispute Resolution Committee of KISA, where he deals with KRDRP as well as ADNDRC UDRP cases. Now that I've introduced our panel of speakers, please allow me to get into the topic of our discussion. When we talk about ADNDRC, I think it's important for us to talk about a little bit on the procedure for UDRP matters. A typical UDRP proceedings would usually begin with the filing of a complaint. And the complaint then comes to the provider. The provider will have a couple of things that we will do. First being reviewing the complaint and thereafter sending across the complaint to the registrar to lock the domain. Now, the one person who sees the entire procedure from the beginning up until the very end would be a case manager. Now, on that note, I would like to direct my first question to Eric. Eric, from the case manager's perspective, what are some of the common issues that a case administrators would usually encounter when administering a UDRP dispute?
Thanks a lot, Priscilla, and thank you again as well to AIAC for inviting me to attend the annual conference and participating in this session. At HKIC, we have dealt with quite a number of domain name disputes under UDRP, but also under CNDRP and HKDRP, which are the more regional specific procedures. But everyone here is probably more interested in the UDRP, and so my points are going to be in respect of the UDRP specifically. And you're absolutely correct in that the one person who's going to see it from the time that the complaint is filed all the way to the publication of the decision is the case manager. Now, the case manager's work in terms of UDRP, as you might expect with most arbitral institutions, with most arbitrations, 80 to 90% of the case manager's work is actually from the time that the notice of or the complaint is filed to the appointment of the panelist. Obviously, there's some work that we do with the panelist in terms of monitoring, but once it's in the panelist's hands, our work or our job as case managers is typically finished. So what I'm going to be speaking of primarily is in terms of the complaint itself, in terms of compliance with the UDRP procedure and the case manager's role in terms of reviewing that, making sure that it's free of any deficiencies or how the case manager deals with a notice of deficiencies when responding to the complainant. Now, a statistic that we're probably not very proud of is that close to 100% of the complaints that are filed before us in first instance have some sort of deficiency in them. And so the notice of deficiencies becomes a very common aspect of the case manager's role. Now, why is that? Common sense should say that a complaint should be free of deficiencies because we have the templates posted online. The complaint form is posted online. It is a form process. So common sense states that a complainant who's making this complaint should be able to provide a complaint that's free of deficiencies. Well, there's a couple reasons why. Well, and this was actually raised in the first panel, in that in many of these cases that you're talking about transfer of a domain name, you're talking about bad faith actors. You're talking about cyber squatters. You're talking about people who are using the domains for phishing exercises or using it for other intents and purposes. Those people, until they have a hook or somebody that they can reach out to, don't want to be found. Now, if we look at the UDRP rules, Article 3B5 requires you in your notice of complaint to provide the postal addresses, the email addresses of the respondent, as well as their telephone number and their fax number. Now, I mean, I don't even know my own fax number, much less the fax number of the respondent. And this is not information that you're generally going to be able to find on a WHOIS search. Even if you have a normal registrar who is going to have this information in WHOIS, you're typically not going to be able to find this published on the WHOIS. And this is ignoring the fact that many of these bad faith actors are going to be using confidential registrars or employing confidential privacy protection services so that you can't even identify the names on the WHOIS search. What that means is that the complainant who is filing a complaint is probably going to be filing that complaint with very incomplete information. They're going to know the domain name that they want to have transferred. They're going to know the reasons why it infringes the trademark. But in terms of identifying the respondent and being able to figure out the details of that respondent, you're going to need the help of the DNDR and you're going to need the help of the registrar. And so a lot of the work that we're doing as case managers is actually working with the registrars. Once that lock, we've asked the registrar to put that lock in terms of identifying the information of the respondent for the purposes of not just the panelists, but the complainant themselves as well. And so this is the first point that we deal with in terms of as case managers, is just making sure that we have a complete file in terms of information. Another point that we deal with quite often is that in many cases, domain name has expired by the time that a transfer is being sought. And then the question becomes, well, is the complainant willing to renew that domain name if they have transferred it? Because otherwise the registrar won't act. Obviously, they don't get the money if the domain name has expired and there's no money involved there. So expiration becomes a common issue that we deal with as case managers. The issues of consolidation. Now, the UDRP rules provide for consolidation of certain domains, but there are certain requirements for that. And in many cases, if a complainant is making the complaint in person and they don't have a lawyer or a firm which is representing them that is experienced in the UDRP, they may ask for a consolidation when consolidation actually isn't possible under UDRP because we're talking about different parties to the various different domain names or different registrars, different aspects in terms of consolidation. And then that's still something which then we as case managers have to go through that process of dealing with the complainant and the registrars in order to ensure whether or not a matter actually can be consolidated. And then finally, we have to understand that when we're talking about implementation of a UDRP procedure, we're not just talking about the UDRP rules themselves. Every domain name dispute resolution provider has their own supplemental rules, and that is envisioned in the UDRP itself. Now, the ADNDRC has its supplemental rules. Those supplemental rules provide for the emails and the processes that are to be supplemented to the UDRP, but some of them are not necessarily intuitive to a complainant. One of those, for example, just to bring up one example that we deal with on occasion is Article 13 of the ADNDRC supplemental rules. Now, the Article 13 of the ADNDRC supplemental rules provides a word limit on the complaint, and that's for very common reasons. You want the complaint to be short, succinct, and to the point so that the panelists can render the decision in time. Well, we have a 3,000 word limit in the supplemental rules. Sometimes complainants don't notice that, and so we sometimes get submissions that are 5,000 words, 6,000 words. I think at one point last year we got something which was on the order of about 12 to 13 pages. Obviously, this goes far beyond what the complainant's able to or should provide in order to make the panelists render those decisions. And so those all create issues in us going back to the complainant and trying to get those deficiencies rectified. Now, why am I talking about all of this? Because obviously, once the notice of deficiencies is sent out to the complainant is going to rectify it. So it may seem like I'm making this sound as if this is a mountain out of a molehill. But we have to understand that the entire UDRP process is designed to be time efficient and cost efficient. right? There is a reason why panelists have to render the decision within 14 days. There's a reason why the fees are kept at a relatively low level. When work is put in on the case manager's level, that in order to rectify these deficiencies, right, with some of these issues being almost inherent in the procedure itself, it affects the time it takes to have a decision rendered. And that is something which, every institution, including especially HKIC, because we focus very much on time efficiency, is something that we want to cut down as much as possible. And so if we eliminate these pain points, if we make it clearer to users what's necessary, and we raise awareness of the procedures such as the supplemental rules to ADNDRC, we make the process as a whole more efficient. And that in turn, it drives adoption of UDRP and ADNDRC amongst all the users. So this is why we focus at the institutional level on things as small as word counts and word limits, which for a practitioner sounds strange, but it all adds up, and it's something that we focus on very much so at the center. So thank you, Priscilla.
Thank you, Eric. I think you brought up a really interesting point on the fact that, reaching out to the registrar to get information on the respondent is rather time consuming. From the AIC, I think some of the issues that we've encountered would be reaching out to the registrar in itself sometimes might be time consuming. And this in turn affects the entire time limit to conclude the entire proceedings as well. So I get where you're coming from. But the other thing that really stood out from what you mentioned was actually the awareness on the supplementary rules. The supplementary rules were recently updated. I believe it was on the 21st August this year. And when you take a look at the supplementary rules as well as the ADNDRC rules, there may seem like there are a little bit of overlaps between these two rules. On that note, can I then turn my question to Hang Ming? Would you like to perhaps walk us through a little bit on the filing of a complaint? To what extent does a provider review the complaint? There is a provision on the ADNDRC rules, I believe it's Article 4, which talks about this, and the supplementary rules, Article 6, also mentioned this. Could you walk us through on that, please?
Thank you, Priscilla. Can you hear me? Dear distinguished panelists, colleagues, and friends, thanks a lot for attending the conference. I'm Hang Ming, Case Manager from CTEC and the ADNDRC Beijing office. CTEC is one of the major permanent arbitration institutions in the world and the leading international commercial arbitration institution in China, as well as one of the founding offices of the ADNDRC. CTEC accepts commercial arbitration cases and provides the international arbitration service, as well as other ADR services like the domain name dispute resolution, mediation, construction dispute review, and APAC ODR service. For my daily work, I find a complainant often cares much about the compliance review of the complaints conducted by ADNDRC. So I am very glad to take this opportunity to share my view on this. The complainant often files a case with the complaint and its annexes, the certificate of a good standing and power of attorney. After receiving the filing of the complainant from email, we will examine the complaint within 3 days for compliance with the policy, the rules, the supplemental rules, and shall notify the complainant of any deficiencies therein, according to Article 6 of the supplementary rules. Then the complainant shall have 5 calendar days to remedy any deficiencies identified by ADNDRC. According to Article 3B of the rules for the UDRP, an acceptable complaint shall fulfill the requirements such as identifying the disputed domain name and its registrar, providing details of the parties, summarizing the factual and legal grounds, confirming the remedies sought, electing to have the complaint decided by 1 or 3 panelists, and so on. It seems to be a huge task for the complainant, but don't be worried. ADNDRC has prepared templates for of the complaint, the Form C as we call it, and guidelines for electronic submissions. When you follow the instructions, you will find a way to a successful submission. We don't pay much attention to the annexes, which are the supporting documents for the complaint, but we sincerely suggest the complainant to list out the number and name of the evidence. This is advisable if you pen some words to describe your purpose of proof. Then when we review the documents, we can double check whether we have received all your submissions. We'll explain more about the certificate of good standing and the power of attorney. A certificate of good standing certifies that a company is properly registered with the local government and is legally permitted to engage in business activities in the country. It may also be called a certificate of status or certificate of existence. The complainant shall provide its company registration documents to prove its existence and legitimacy when filing a case. These documents shall be the latest issued by the local registration offices, and of course, it cannot be artificially modified. The complainant should pay attention to its accuracy. All the information in the complaint about the complainant shall be identical with these documents and shall be proved by these documents. It should be noticed that the registration information, trade name, and address shall correspond with those recorded by the trademark certificates. The complainant should also provide additional documents to prove the signatory authority. These documents are closely related to the validity of the power of attorney. Compared with the commercial arbitration disputes, the domain name cases are often not that complicated, and the less value of the subject matter involved in. It is common for the examiner to apply a stricter standard to those complicated cases, while a weaker one to those not that complex. But I find that attorneys often represent the complainant not only in the dispute resolution proceedings, but also in the enforcement procedures, and have a decisive influence to the final result of the disputed domain name. So I think we cannot judge a case by its value of subject matter, and every case deserves earnest and meticulous treatment. First, its content should be accurate and concrete. It's often the case that the complainant, especially the large and the successful enterprises, has more than one authorized trademark rights, and they may discover domain name infringement more than once. They need to file for more than one domain name case. In order to avoid repetition, the attorneys may ask for an authorization in the package of these trademark rights. So the attorneys will try hard to broaden and extend the scope of authority, which usually turns out to be obscure like this. It reads that the attorneys are authorized to take all steps to discourage and eliminate imitations, counterfeits, and any act that constitutes infringement or damage of the legitimate rights regarding the trademarks, patents, copyrights, or other IP rights of the complainant. There is no words about the attorney has the authorization to submit a complaint to ADNDRC, and no words about what the disputed domain name is. Or even more outrageous like this, which will be a critical procedure mistake because of its logic error. It reads that the authorized party can file domain name dispute resolutions with a CTAC against infringing domain names that are identical or similar to the commercial signs of the authoring party. It can be interpreted that only when the panel decides that the disputed domain name is identical or convincingly similar to the trademark of the complainant, can the attorney has the authorization to file the case. In other words, if the panel rejects on the first element provided by Article 4A of the UDRP, the complaint submitted by the attorney is fundamentally invalid. Second, the content shall be confirmed by the complainant or qualified and powerful delegates of the complainant. The power of attorney shall be sealed or signed. As a common sense, the policy of usage of seal diverges among different countries or even different states of areas in one country. For these companies, for those companies that use a seal, the attorneys shall submit an power of attorney with the signatures of company delegates. Power of the signature of a delegate is different from one company to another, which is governed by the local company laws and or articles of incorporation. A signature of a shareholder or chief intellectual property officer is not always equal to a powerful authorization. So we usually invite the complainant to make a statement on name and position of the delegates and provide its complete registration documents to prove the signatory authority. That's all I'm sharing with you today. Thank you.
Thank you, Hanming. So I guess from Hangmin's presentation, you would know to what extent would a provider review the complaint. So ideally, what we're trying to convey here is mistakes are bound to happen, deficiencies might happen, but if you can opt to attempt to not make any mistakes, at least then we could sort of save some time on the back and forth for notice of deficiency for you to remedy that deficiency. At least then we could, complete the entire proceedings in a given time. Now, we've heard from Eric and Hangmin on some of the practices and some of the things that a case manager would implement when reviewing a complaint, as well as when they are overseeing the entire procedure. Can I then turn to Yun and ask him to explain to us a little bit on the case updates that you have encountered in KISA?
Nice to meet you. This is Yun from KISA. We also have like a common problem, like as mentioned, Eric. Yeah, so we every time we get a complaint from and then we try to get to registrar, and then also we confront the problem to reach and to register the information. So let me introduce my presentation. Okay, so KIDRC, we joined the ADNDRC and provide the GTLD dispute resolution service in 2006. KIDRC is run by KISA, is a Korea Internet and Information Internet and Security Agency, and the KISA covers a lot of like a business, like from cybersecurity and then KRNIC. So now we KIDRC is a small department of the KISA. So we okay, and then we now we have like 5 Korean panels activating in ADNDRC, and they are 3 professors of a law school and then 2 patent attorneys, and then 2 more Korean panels is going to be added from 2024 next year. So 1 attorney at law and 1 patent attorney. This is what we Korean part. What Korean part joined ADNDRC? It's kind of looks like a very small part of ADNDRC. This is what we are. Yeah. Let me give you UDRP case figures dealt by KIDRC. We have look at the number of complaints. We can see I give you about 10 years number of cases. You can see we annually we are dealing with about 10 cases, and then usually the cases from Korean companies, usually big company, and Samsung or almost Celltrion, and most of the cases come from Korean big tech companies. So this and then the result of complaints is about over 90 or 90%. The cases got to transfer. Yeah. So this is what the figure is. Yeah. I can give you a panel appointment in Korea. So we have like 5 panels in ADNDRC. For most of cases, KDRC accepted. We point Korean panels. So if you, this is, but if your cases are increasing rapidly, so we would reconsider this another option, so to point another, foreign company like China or Hong Kong. But this time we can manage it to point just Korean panels because we have just but 10 cases annually. So next time, all of cases, a single panel is selected, and except just one case is for recent 3 years. But this year we have just 3 panel cases. But this time we are considering to point foreign panels because we have just 5 panels in Korean, but we think we cannot appoint all Korean panels for 3 panels. So, this might be the first case for us to appoint foreign panels soon. Yeah. Let me give you some best practice for Huron company in Korea. The complaint was filed on April this year, and ADNC, the case number is KR blah blah blah, and complainant is a Huron company. You might know the Huron. Yeah, I mean this is very famous in Korea, and then the respondent is Christopher Alexander of Canada. Dispute domain names, they complained about 4 domains: HuronUS.com, USHuron.com, USHuron.co, HuronTM.com. They sought to remedy transfer, and decision is got to transfer on June. Yeah. Let me explain more. Huron Company of Korea was established in October about 1979 with the name of Donga Industrial Corporation, and changed its name, the current one of the June 2011, and it is primarily engaged in the manufacture and sales of home appliances. It's like a kitchenware, like as you've seen in before slide, and like a fruit blender, and in the home kitchens. Yeah, but that brand is very famous for the home appliances. And then Huron also, has overseas subsidiaries in the United States, Japan, and China and German, and collectively used the human since 2006 as a, what is this? Yeah, the brand name, and since 2011, and the company brand name, and since 2008, have registered the brand name as trademark around the world, including Korea, China, and UK, and the US. And then, but at in-house patent, Tony is a friend of mine of a Huron company. He contacted me and about the seeking remedy of cyber-squatted of Huron domain names. They collected a lot of the cyber-squatted domain names in their internal companies. So then we guided him to file a UIDRP complaint, and then finally he got a transfer of the dispute domain name on June this year. After they got transfer of a UDRP case, he said, there are many other internal demand to resolve many other domain name cases. So one of them are above Tapma in the Malaysia, and then we inform him of so AIAC is dealing with Danmai domain name dispute cases. So hey, you can file a complaint to the AIAC. So, and then recently I heard that he said to me they had filed a complaint and the AIAC, and then got a transfer of my domain of Hurom. So Hurom is widely known, and then but not much more than Samsung or Hyundai in Korea. But after we guide him how to resolve the domain dispute cases faster than lawsuit, and then they are satisfied and trying to use DNDR service and continually. So he asked me a lot of more things about how to deal with another CCTLD cases. So, but as far as I know, I can let them know that you can go to the here and go here. Yeah. So this is what we reach out our so giving them an information about how to resolve the domain name dispute case. Yeah. We have another cases. Have cases about change of proceeding languages. We use in Korea. Many people are very, very familiar with Korean, not English. But second language of familiarity in Korea is English, but not other languages like China or other anything. Other languages are very they could not understand how to do. Yeah, but so ADN, Samsung Electronics is they raises many cases to us and then to ADNDRC, to WIPO, and then they raises a complaint about SamsungUkraine.com. Yeah, the respondent is Ukraine. You can see a Ukraine name, but I could not read out. And then the registrar is also the Ukraine company. So they need to write the Ukraine languages in complaint form, but it is not easy. Even in the Samsung big company, they cannot. They have not easy to make an Ukraine complaint. Yeah. So, but we see the website of the dispute domain name is designed in English and then sell Samsung products in English. So then we discussed with the panel and then changed the proceeding language from Ukraine to so English. Yeah. And the other cases, this is cases also from Samsung, and the respondent is Korean. After we contacted the registrar is in the United States, but after we contact the registrar to get registrant information, finally we can see the registrant is Korean. Yeah. So, but first of all, the Samsung have filed a complaint in the English version, but the respondent is Korean and complaint is Korean. So, but we cannot proceed the cases with English because the respondent have a complaint, give us complaint why this version is English. I cannot understand. Please give me another Korean version. So we the panel and change the proceeding language from English to Korean. So, this is apart from ADNDRC, we some publish our CCTLD DNDR service provider in our website. So because we this KIDRC is the only domain name dispute in Korea. KISA is a public sector, and some customer or demander, they ask me to where to go to regarding a lot of CCTLD. So we searched and so posted major 20 CCTLD service provider in in our website, like New Zealand and then Taiwan and then Malaysia and then Vietnam. Vietnam they do not have DNDR provider. They have to go to the court, and then Singapore, Asia, India, and or also you are showing the America or Canada. Yeah. This is very informative to Koreans. So Koreans are very happy to see this chart. Yeah. This is what I have. Yeah. Now.
Thank
you very much.
Thank you, Yoon. So as Yoon has rightly pointed out, in the AIC, in addition to just administering ADNDRC disputes, we also administer MINIC disputes. And these are domain names which consist of .my disputes. We also have the representatives from the registry for MINIC who are with us here today. I think they are somewhere seated there. I believe we still have 2 minutes. I was initially strictly instructed by Ezra to not take up your lunchtime. He's already giving me some look there, but we do have a couple of questions in the chat box, and I would like to perhaps just start off with one question. The question that we have here is, after a denial decision, the refiling of a complaint against the same domain name is prohibited in the absence of a new evidence. Do you feel it should be the dispute provider's responsibility to search for any prior decisions involving the same domain name and inform the panelists of such findings? Perhaps, Eric, would you like to take this question?
Sure. I mean, and it's a very good question. And we have actually had that situation arise in one of our matters where we had a domain name decision that was given to us. We went ahead, we appointed the panelist. The panelists actually proceeded to render the decision, and it was only when they were doing their final checks realized that the decision had actually been decided before. And luckily, in that situation, the decisions were consistent, so they could go ahead and proceed with it. But it does raise a very good point. What is the extent that the service provider has to go to look at whether or not there's been a pre-existing decision? This is where it gets a little bit trickier, because we can look obviously at matters that we have looked at before. We can look at decisions that have gone through HKIC and to some extent through ADNDRC, but not necessarily if it's gone through another service provider, like say WIPO. And so even as a provider, there are limits to the visibility that we have. And so really, I would say it's not just the provider's obligation and duty to look at it. It's also on the party that's making the complaint to give full and frank disclosure if a decision's been denied before. And it's also on the part of the panelist, and probably at an early stage. One of the things that, obviously there's some sensitivity to, but one of the things that we didn't really discuss is panelists. And obviously, when you're dealing with sometimes experienced panelists, they think, well, I can knock this decision out in 2 days. So on a 14-day timeline, they look at it on day 12. And I see Ezra laughing because he knows exactly what I'm talking about. And they look at it in day 12, and there's only when they look at it, they realize, ooh, there's something there which I hadn't seen before. Either there's a conflict of interest, which I wasn't aware of before, or the languages of some of the documents are not what I expected. Like what Yoon said, well, we have a lot of cases where the registration agreement's in English, but documents are in Chinese. We appoint the panelists, and on day 12, the emails to say, hey, I can't read Chinese, and 90% of the documents are in Chinese. At which point, now as a provider, we have the situation of having to appoint a substitute panelist at a late stage in the proceedings. So these situations do arise. What I would say is that if you are being a panelist, open your file on day one, take a look at it, make sure that there isn't a pre-existing decision and that you can read all the documents. And I know that sounds strange, but please open it up on day one so that if a situation does arise, we can deal with it at an early stage of proceedings.
Thanks, Eric. And I cannot emphasize Eric's point enough as well. Even from a case manager's perspective, even I have experienced instances where on day 13, the panelists reach out to me and tell me, I'm sorry, but I can't open your file. So please, yes, please take a look at your file on the very first day and let us know if there's any inconsistencies that you would like us to take a look at, or if there's anything that you think we should be aware of. You know, we wouldn't know what are the issues that you encounter unless you don't tell us as well. So these are some of the things that you should keep an eye on. The second question I have, perhaps I could direct this question to Hang Min. Do all officers of the ADNDRC require to submit a certificate of good standing of complaint, or is it just the Beijing office?
I think it's a good question to maybe other offices of ADNDRC, because all the case managers of ADNDRC Beijing office use the same standard to all the cases we accept. Thank you.
Thank you. Okay, we are already 2 minutes past 1. Sorry, I think we have one question on the floor here.
Yeah, I have two quick questions. My name is Sushil Shankar. One is for Eric. You spoke about consolidation in terms of consolidation of parties. Is there also such a thing as consolidation where the infringer registers several domains under different TLDs? Like we saw the Hurong example, .co, .net, .org. Or do I have to fight against this infringement for each of these domains separately?
We do see that where the complainant's trying to consolidate against a single respondent, but there's multiple TLDs involved and multiple different registrars involved. And then obviously it's a case-by-case basis, but typically speaking, those are situations where we wouldn't be able to consolidate because we are dealing with different registrars. In many cases, you're dealing with different languages of the registration agreement, because one of the common problems we see, at least in Hong Kong, is that they'll register it in Hong Kong in English, they'll register it with Chinese registrars in Chinese. If the languages of the registration agreements are different, then it makes it very difficult to consolidate. And then if you're looking across different TLDs, then obviously there are some difficulties there. So I'm not saying it would be impossible, but it would make it a little bit more difficult for us to determine that.
But if you do accept the consolidation, will the claimant have to pay the fee just once or for each of those domains?
Those fees would be in accordance with the schedule. So I think probably it would be listed as the number of domain names that you would have under.
Okay, thank you. Priscilla, one more quick question.
Ezra is looking at me and he's very angry.
Ezra? Yeah, okay. I have his permission. Okay. So actually this question should have been for Jin Lee in the previous panel, but there was no time. So as I understand it, the decision of the administrative panel, the DNDRC, is not final if there is a court proceeding also. And of course, the Malaysian court seem to have taken the view that they can't involve themselves. But in how does it work in other jurisdictions where, let's say, the court takes an opposite view of the DNDRC?
I mean, I think the Hong Kong position is pretty similar to Malaysia, but I haven't looked at the latest court decisions, so I wouldn't be able to say that with 100% certainty. What I will say is that in very, very, very few of the domain name decisions that are issued by panelists are subsequently tried to be reopened in court. And we definitely haven't had a situation as abusive as what was talked about by in the Malaysian courts.
Thank you. I won't keep people from their lunch any longer. Thank you.
Thank you, Captain. I can hear your stomachs rumbling already, and Ezra is still staring at me. With that, I would like to thank our esteemed panel of speakers. Thank you, Eric. Thank you, Yoon. Thank you, Han Ming. And back to you, Ezra.
Thanks, Chris. That was very nice of you.
Thank
Thank you
you.
to our panel of speakers and moderator for a very good session. Thank you very much to Mr. Eric Ng, Mr. Yoon Gae-sung, and Ms. Hang Min, who joined us virtually. We'd love to have you here physically for our future conference. Now, we'd like to invite Assistant Director of the AIAC, Ms. Heather Yijinghua, on stage to present a small token of appreciation to our speakers. And to Hang Ming, we'll find a way to get it to you in China. Don't worry about that. Thank you very much. With that, ladies and gentlemen, we've come to the end of the second session. Without taking more of your time, may I invite you all to join us for lunch at the pre-dining area at the lower ground floor. There'll be ushers to guide you at the entrance. And I'm scared to go and see Bahari and Priscilla now, so we'll head off quickly. Thank you.
A very good afternoon and welcome back. Just as a quick introduction, my name is Ragini and I'm a case counsel at the AIAC and I'll be your interim MC for now. Without further ado, let us proceed to the penultimate session of the day entitled Into the Future AI in UDRP. Unfortunately, we regret to inform that Mr. Chai has been caught up with some personal and emergency issues, but rest assured he will be joining us shortly. But till then, we'll have Mr. Ezra to moderate the session 3. I would like to call upon our interim moderator for this session, the AIAC's very own Mr. Ezra, to come up on stage to kickstart this session. Over to you, Ezra.
Thank you, Ragini. Sorry, you didn't see my face on the flyer, and I'm really sorry you have to see it now. But unfortunately, as Ms. Ragini has just said, Mr. Dennis Chai is caught up with a bit of an emergency situation, and we have to accommodate accordingly. Joining me up on stage is Mr. Soka Liang. Ladies and gentlemen, please give him a round of applause. And joining us virtually is Mr. Doug Eisenberg, all the way from Atlanta, and Mr. Eugene Lau from Hong Kong. Thank you so much for joining us, gentlemen. And we're really sorry about the current situation, but we'll have to proceed. And I think, Karlang, you're going to have to help me out a lot here. The topic is on AI and UDRP. And now we've heard a lot in the first 2 sessions on a general broad stroke of domain name disputes for all of you who may not know. And then in the second session, you heard from the representatives of the ADNDRC Center on specifics regarding procedure. And now in this part of the conference, sessions 3 and sessions 4, we'll look to the future. One of the biggest threats and emerging factors is artificial intelligence in the domain name sphere. And I'm proud to have 3 distinguished experts in the area. And to kickstart, I'd like to invite Mr. Eugene Lau to briefly paint us a broad stroke picture on what the current state is on artificial intelligence in the domain name sphere. If you could, Eugene, just jump in.
Thank you very much, and very nice to meet you all virtually. Just as a very quick introduction, AI, as you know, artificial intelligence touches on many aspects of our daily lives and our work. And in the domain name world, I think AI touches on many aspects. For example, and I know Doug will be showing a video shortly. For example, AI can, whether AI tools can help panelists draft domain name decisions or even make the decisions themselves. And whether AI tools can help complainants and respondents draft their submissions and arguments. Also taking a step back, whether AI tools can help trademark owners monitor and detect problematic domain names. And perhaps flipping the coin a bit, there might also be AI tools in the market that cyber squatter make use of them to create copycat websites and domain names. So indeed, I think AI tools certainly is fast developing area, and its application to the domain name world is, as I have just given some examples, I would say fascinating, and a lot of exciting developments in the pipeline.
Thanks, Eugene. Taking on from your general view, Kaliang, do you have anything to add regarding the resurgence or the growth of AI, at least in the Asian region, particularly Malaysia and Singapore? Is there anything to add?
A lot is going on, but I thought maybe it's useful to bring us back to the basics, because most people refer to AI as something very scary, and I think it's also a result of us growing up from the last 2 decades of science fiction, and I know that there are some Trekkies, closet Star Wars fans among us, whose impression of AI is robots, whose impression of AI is smarter than you kind of entity, creature, spirit. And there's actually, in my view, a lot of confusion about what AI is. And what might be useful to realize is the AI that we are confronted with this year, and this year is coming to the end, and the resurgence of this interesting concept of AI all came about because of news that was released in the very early part of this year about ChatGPT. Before that, nobody really cared about AI. And with that, I thought I'll share a little bit of my personal history. I was educated in a master's in computer science, focusing on AI. But at that time, when I was studying AI, just barely last month, so I'm quite young, AI was not understood as AI you see now in what might be represented in ChatGPT. AI was seen as a tool to combine a lot of information together and to train some knowledge base so that certain predictions can be made. And my personal focus at that time was the prediction of three-dimensional shapes or protein structures. So based on amino acid sequences, that was my background. It's a bio background, but IT at the same time. So that is a very far cry from what you see in the movies, Terminator, Skynet. We heard a case about Sky World earlier this morning, but it's not the same. So we hear about Skynet, okay, taking over the world with robots, enslaving human beings. And then for those of the fans here of the Matrix, human beings being used as batteries for machines because of our electrical impulses in our body. So that's the kind of background many of us come with into this setting about what AI is. But That's not what AI is, even right now. That kind of AI is called artificial general intelligence. But the AI we're dealing now with is probably in the current iteration, generative AI. And there's a huge difference. So I thought it might be useful at this time to maybe pass the time on to Doug, because he's got a wonderful video to show us. I don't know, Doug, do you want to show the video now, or do you want to speak about some things first before you show your video?
Thank you, and I want to make sure everybody can hear me fine. If not, you can let me know. And I'm honored to join you, as was said, from Atlanta, Georgia, in the United States, where it is, of course, the middle of the night. But I'm very happy to be here on this important topic. And yes, I do have about a 5-minute excerpt from one of my recent videos that I think is worthwhile to show. But maybe before we do that, one topic is we talk a lot about AI and what is AI. One interesting issue that's come up, especially this year, is a renewed interest in the .ai top-level domain. As everybody knows, there are 300 or so CCTLDs, or country code top-level domains, here in the United States, of course, .us. So Anguilla, which is a British territory in the Caribbean, is home to the .ai CCTLD, which has not attracted a whole lot of interest through the years, but has now, relatively speaking, surged in popularity with respect to domain name registrations. Maybe not relatively so many. There are, by means of comparison, I think more than 250 million .com domain names that have been registered. Only about 250,000 .ai domain names. So only 1,000th as many .ai registrations. But what has happened is, just because of .ai's coincidental representation as the acronym for artificial intelligence, just like some other CCTLDs have proven popular. .tv for Tuvalu is an abbreviation for television. .md for the Republic of Moldova has been used by a number of medical doctors. .ai has attracted attention, especially this year, among domain name registrants and trademark owners, and of course, among cyber squatters, which is where the UDRP comes in. So what's interesting to note is the .ai CCTLD registry operator has adopted the UDRP. In other words, domain names that are registered in .ai are subject to UDRP disputes. And there have been about 50 or so decisions across all of the UDRP service providers this year, which again does not sound like a lot, but it's about a 10-fold increase over last year. I know personally, because I filed a number of complaints, the actual number of complaints that has been filed is even much higher than that, because many, if not all, actually, of the .ai complaints I know that I filed for my trademark owner clients have resulted in settlements. So there are no decisions. So those don't get reported in the same way. But anyway, the point is, I think it's interesting to note that this is a top-level domain that has attracted attention just because it coincidentally is the acronym for artificial intelligence. But yes, if it's appropriate, I'd be happy to go ahead and show, it's literally a 5-minute excerpt from a video that I'd created earlier this year, in which I looked at whether it would be appropriate and how some of the popular artificial intelligence tools that are available to all of us could be used during the UDRP process. Is that okay? I believe I can.
Yes, you could just share screen, and I'm sure there's nobody from ChatGPT or any of the AI companies here. So please, by all means, Doug, thank you.
Okay, great. Let me just go ahead. Forgive me for just a moment. I want to get it to the correct starting point, and then I will play it for everybody here. legal profession. So against this backdrop, how could I ignore the possibility that AI might magically improve my legal practice focusing on domain name disputes? To test out ChatGPT and 2 other AI services, I decided to ask them very specific research questions on both substantive and procedural issues that sometimes arise when drafting UDRP complaints, to see if they could either write actual legal arguments for me, which I might then cut and paste into my own documents, or at least point me in the right direction with relevant citations to previous UDRP decisions that I could then read and use as precedent for my own arguments. So first, I turned to ChatGPT, the tool that's certainly the best known among all of the AI products that have been in the news in recent months. I entered this query: provide a list of the top 5 most relevant UDRP decisions that explain when it is acceptable to add a domain name to a complaint that was already filed if the due date for the response has already passed. Now, this is an issue that arises from time to time, and it's something I've talked about in a previous video on the Gigalaw YouTube channel. At first glance, I was impressed. After issuing a disclaimer that ChatGPT is an AI language model that doesn't have real-time access to current UDRP decisions, which, by the way, I'm not sure why that's the case since decisions are promptly published by all of the UDRP service providers as ICANN requires, ChatGPT then said that it can provide me with a list of 5 notable UDRP decisions that address the question I asked. But then, as I actually looked up the 5 cases that ChatGPT listed, I saw that not one of the case names actually matched the case numbers provided. In other words, I had received 5 faulty UDRP case citations. And while the short summaries that ChatGPT listed were informative, they were not accurate summaries of anything in the decisions that correspond to the case numbers. In fact, 2 of the 5 cited cases were terminated. So there are no decisions there from which anything can be learned. As for the other 3 cases, none of those that match the case numbers actually allow the trademark owner or complainants to add a domain name to the case, even though the summaries specifically said that they did. Okay, so next I turned to Bard, Google's AI tool. And here I asked it a substantive question. Describe the circumstances under which a UDRP panel may find bad faith where the disputed domain name was created before the complainant's trademark rights arose, and list the top 3 most relevant cases. This is also an important UDRP issue, one that some trademark owners sometimes misunderstand, and one that I've also addressed in a video on the Gigalaw YouTube channel. Bard presented me with 3 bullet points that it said answered my question. But in my opinion, 2 of the 3 were just plain wrong. Bard told me that a UDRP panel may find bad faith where a respondent uses a domain name in a manner that is likely to cause confusion, or where a respondent tries to sell a domain name to a complainant. But neither of those scenarios addresses the timing of the domain name registration versus the establishment of trademark rights. So relying on Bard's answer alone would most likely be fatal to a UDRP complaint. The WIPO overview, perhaps one of the most often cited documents about the UDRP, provides important information that can help answer my question, but for some reason Bard did not even mention it. And much like ChatGPT, Bard provided case citations that were inaccurate, with none of the case names matching the case numbers. And interestingly, the case that was cited first in the results was actually for the famous Telstra versus Nuclear Marshmallows decision, even though Bard listed a different case name, which addresses the issue of how to establish bad faith in the event of passive holding, which has nothing to do with the question I asked. So finally, I tried out Microsoft's Bing AI tool, which is powered by ChatGPT, but has been touted by Microsoft as being more powerful than ChatGPT. Here's what I asked Bing AI. What are the leading UDRP decisions allowing English as the language of the proceeding, where there is no website associated with the disputed domain name, but the domain name itself consists solely of words in the English language? Again, this is a topic that arises not infrequently, and it's the subject of another of my videos on the Gigalaw YouTube channel. And again, the result was disappointing, though this time for another reason altogether. Instead of giving me any UDRP case citations or any useful narrative, Bing AI simply provided what looked like a list of search results, 2 of which, by the way, are to resources on my own Gigalaw website. And these did not appear to be some super-powered list of resources that was better than I could have obtained in a traditional search engine. In fact, one of the links for the WIPO overview that I mentioned earlier was actually for an outdated version of that document, which was replaced by the current version 6 years ago. Hopefully that played well and sent a strong message that it's dangerous still to rely on any of these tools for legal research. Still takes a human being to conduct research and analyze whether it's a complaint or a decision or a response or any other legal filing.
Thank you, Doug, for that video. That was perfectly timed. And unfortunately, I'll have to bid you goodbye because our actual moderator has arrived, and Mr. Dennis Chai from Hong Kong. We invite you up on stage, and we're very glad that you're feeling okay. We had some concerns, but I'll pass the floor over to the moderator. Thank you.
I'll miss you, Ezra.
You can join me. We can have one chair exchange. Thank you, Karen, and good to see Doug and Eugene. I'm sorry that I'm getting late because my throat has a little bit problem, so I hope you don't mind. And I think you have a very good start headed by Ezra. So have we introduced the development of AI before?
Yes, we've done that. And Doug has actually shared this video.
Yes,
which has been very insightful. In fact, I do have a question about the video that perhaps not directed at Doug alone, but maybe it's for free discussion, which I think might be useful to the audience. I think generally from what Doug has shared is that AI is not reliable, or at least ChatGPT, Bing, and Bard have certain reliability issues. And I feel that that comes from a human expectation. When we have the idea of artificial intelligence, we somehow think they must be smarter than us. But would you consider your wife or your husband to be intelligent? If you do, then how can you expect artificial intelligence to be, well, more intelligent or less important than your spouse? Essentially, we're human beings, aren't we? We're intelligent to some extent, or that's what we believe we are, but we fail too. And ChatGPT, Bing, Bard, intelligent in some ways, they're also entitled to fail. So as professionals, I think shouldn't, when we rely on someone to do something, for example, my legal associate, I'm not going to just take it at face value and submit it to the court, am I? I have to check, I have to verify. So I was just wondering, do you notice that there is this kind of like expectation of natural intelligence beings like us setting a very high standard for artificial intelligence, which might actually be unfair to them if they have a place to complain about it?
Okay, thank you, Karen. And writing on your answer, I just pop up with one question. What about if someone use AI and to prepare the UDRP complaint and fail at the first hurdle? So any remedies for that? Or any consequences if one using AI to prepare a pleading and then end up cannot successfully retrieve the domain name? Would it be triggered to the res judicata issue? Any implication?
I'll jump in. I'm not sure if I exactly understand the question, but I think that, you know, as a panelist, you know, when I review case files, I guess I could have been reading documents, whether they're complaints or responses that have been drafted by or use the assistance of artificial intelligence tools already. And I'm unaware of that because there's no requirement that the parties refrain from using AI tools. And there's no requirement that the parties disclose whether they have used AI tools. So in that context, I don't know whether the use of AI really matters that much to the UDRP process. Although I will say that, and I've been a panelist for a long time, unfortunately, I don't think that the quality of complaints and responses, for that matter, but primarily complaints, because trademark owners can choose when they want to file the complaint, how much time they want to spend on the complaint, whether to file a complaint. The quality of complaints, unfortunately, in my opinion, has not been increasing in recent years. If anything, I think just the opposite. And so I'm afraid that the use of AI, at least in its current status, and I think it's improving regularly. So this may be a very different conversation, 1 year from now than it is right now. But that, parties who rely on AI may be doing themselves a disfavor if they don't review what the research is that's presented to them. But I guess I have a greater concern, which is, puts an additional burden on panelists to double check perhaps every case citation that has been included in a UDRP complaint or a UDRP response. And this is not unique to the UDRP process. Just today, for example, a judge here in the United States has asked an attorney in a case actually involving one of Donald Trump's former attorneys to explain himself about a legal filing that he submitted in which the judge says that none of the case citations appear to even exist. So I think it's going to, in some way, make it more difficult because it will be challenging to distinguish actual case citations from fake case citations. And I'm not quite sure how to address that, but it's certainly a concern.
So, yeah.
Well, personally, I have a view that I think it depends on the perspective of the person using AI. So if I'm a complainant, and if AI can generate a better draft than myself, perhaps it might be a good thing to use the AI to generate a first cut and then improve on that. That would save a lot of time. Or if you're a, say, panelist and you're comfortable with the idea of using AI to generate a draft, a first cut of a draft, so you could review, very much like you might ask a junior associate to prepare a document for you. You have to check and you have to ensure that it is good for filing, good for use. So I think the professional burden on, say, a complainant or complainant's lawyer, a respondent's lawyer, as well as on the panelists, I think those remain regardless of whether AI exists as a tool or not. I wonder if I'm overstepping myself and disagreeing too strongly with you, Doug.
Well, I'll just add two quick thoughts. One, if a junior associate submitted a document to me that contained so many inaccuracies, I think I might terminate that junior associate. Sorry to be so direct, but I think it might demonstrate a inability to do the work. The other thing I would say is that I believe, and I'm not looking at it at the moment, and I've just had this thought now for the first time, but I believe there's something in the UDRP rules that states that parties are required to submit as annexes copies of the UDRP decisions that have been cited. Many parties don't do that simply because it seems unnecessary. Maybe now that is actually becoming necessary so that those actual decisions are available as a part of the case file to double check.
So actually that comes as an interesting segue into whether it might also be something that service providers, dispute resolution service providers, whether they have an additional, say, administrative burden to discharge when they receive complaints of this nature. I wonder if there's a thought about whether the the DRP providers, they should do more work as a result of AI.
Yes, that's a good, quite a good suggestion. I mean, yeah.
I think it's a wonderful suggestion. My concern is the UDRP was designed in part to be a very quick, relative to litigation, a very quick process. And so, anything that slows down that process sort of undermines, in part, the purpose of the UDRP itself. I don't think it's a bad idea. I think it's an excellent idea. Just concerned about, from a practical standpoint, how quickly and efficiently that work could actually be done.
Eugene, do you have any thoughts?
Yes, I think Colin and Doug, you've made some excellent points, and I think the good thing coming out of Doug's video is, well, we still have a job to do as panelists, so that is certainly a welcoming message. But I myself, I would not completely rule out the possibility that sometime in the future, AI tools can help, whether help panelists or help the parties with some research on with drafting, or even, who knows, someday they might take part in the decision-making process, because well, AI tools are well, they continue to learn, right? So I don't know when you shot the video, but I'm just wondering, if you ask those questions again today, then you might get completely different answers. There might be better answers. So I myself I'm quite optimistic that well, AI tools would play a bigger part and helping all the stakeholders in the domain name world, and perhaps not just the domain name world, because as I've mentioned, it's whether AI tools can help people with all sorts of legal and non-legal documents, judgments, submissions, letters. So I expect there will be more and more discussions and service providers on this area.
Yeah, thank you, Eugene, and thank you, Doug. Thank you, Carlo. I think we have a very good discussion on how to use AI for UDRP pleading or drafting. But I have actually in the world of arbitration, there are a lot of discussion on AI arbitrator, whether the arbitrator can be a robot with AI capability. But that is risky at this moment. And but for UDRP panelists, could panelists use AI to get a first decision draft? I think that would be risky, according to Doug's view, because of course we should embrace the technology, although it has a lot of drawbacks at this moment. But I hope in the near future it will be improved better and better, to an extent at least to a junior associate level, and to prepare some first draft for to save costs otherwise, because you don't need to pay the junior associate, which is AI, which is quite cost. It is a good experiment, although it has not yet been so successful or comfortable to use in a wide extent, or wider application. So, but we don't have a big conclusion here or not, whether AI can definitely help. But of course, we need to keep an eye on the development of AI. And so, and in talking about AI and domain name, I'm not sure whether we have talked about the .ai domain name. We have already talked about that. That's okay. That's is there any interesting points that any of our panel members would like to share in terms of .ai domain name? Is it a hot topic, or is it good to register one? Any idea?
Doug mentioned some interesting facts about .ai, and I myself, I also handled a .ai domain name complaint a few years back.
Good.
And it is, I guess, one interesting feature in .ai domain name disputes is that for under the first element of UDRP, the complainant probably can make additional arguments that the domain name string .ai also contributes to the computing similarity. especially if the trademark in question is technology related. And in the case that I know a few years back, our client was actually in the AI industry. So that additional argument helped us because the .ai domination definitely added to the confusing similarity threshold.
And I'll just jump in. I think that's an excellent point, Eugene. I'm very glad you said that because it sort of goes contrary to, I guess every rule has an exception. And that sort of represents the exception to the general rule, which is that for purposes of the first element of GDRP, whether the disputed domain name is identical or confusingly similar to a trademark in which the complainant has rights, the rule generally is the comparison to be made is after eliminating the top-level domain. So you don't look at .com as a part of the domain name. That's the top-level domain. Instead, you look only at the second-level domain in a typical UDRP proceeding. But in some cases, and it's not just true of .ai, I had a complaint that I filed on behalf of a healthcare company, and the disputed domain name used the .health CC top-level domain. And so there have been a handful of cases, exactly as Eugene says, involving .ai disputes under the UDRP in which either the complainant argued or in some cases the panel agreed that the use of .ai actually contributed to the confusing similarity because, as Eugene says, in his case, the complainant's activities, the complainant's trademark was in the artificial intelligence space. So there may be some cases in which .ai domain disputes are actually relevant to artificial intelligence issues.
Oh, that's a very good sharing. I think that's a very good decision theory that I think the AI cannot think about. As we are human beings, we can develop this kind of decision theory. And in terms of the use of AI in domain name industry, there could be another area we might need to pay attention to is the domain name monitoring area. Is there any update on the domain name monitoring services of using AI? And wonder if Eugene can share a little bit on that.
Yeah, I'm happy to talk about that. I have not used all the AI tools in the market, but I am aware of AI tools in the market that can help brand owners, use AI technology to help monitor and detect, perhaps not just domain names, but the wider whether there are digital risks happening in social media, websites, e-commerce platforms, mobile applications. So the idea is that nowadays, as we all know, it can be quite difficult to trace who's behind the real identity of the persons behind a certain domain name because of hidden identity, privacy concerns, etc. So these AI tools, the idea is that they can help search and look at a large amount of data online, analyze patterns of registrations, and then they can help provide suggestions on which targets the brand owners should prioritize. Some of them can even generate automatic takedown requests. So I would think these tools can be very useful tools to help brand owners monitor and detect potential issues online. As I said, not just domain names, but the wider digital space, social media, e-commerce platform, etc. But I'm also aware, based on our discussions the other day, these AI tools can also be used by cyber squatters for their activities. So that would be an interesting angle.
Yeah, and I think just to expand on what Eugene was was saying at the end there is I've seen, a number of the domain name registrars and hosting companies are now offering artificial intelligence tools to their customers to easily create websites, which in theory sounds very nice. On the other hand, that tool, when used by a cyber squatter, makes it easier to engage in cyber squatting. I've seen a number of cases, involving counterfeit, the sale of counterfeit products on websites where there are these sort of template or cookie cutter websites that are easily created. I know a number of them can be personalized using AI tools. Just customers are given various prompts to answer about what types of products they want to sell and how they want to describe them. And so it becomes a lot easier to create a website that is certainly using a domain name in bad faith. Many years ago, cyber squatting was originally intended in the beginning, or at least most of the cyber squatting issues in the beginning were exact matches of a trademark in the .com space, usually because the trademark owner was simply unaware of what the internet was in the mid-1990s. How cyber squatting has evolved through the years is very interesting, and I think one of the most popular ways, most common ways that cyber squatters use domain names these days is in connection with pay-per-click websites or monetized parking pages. And I think the reason for that is simply because it's sort of the lazy way to engage in cyber squatting. It doesn't take a whole lot of effort to put up a pay-per-click website. These are websites that create, that display links related to the trademark that appears in the domain name. They're affiliate links. Cyber squatters earn a very small amount of money, so it's all about the number of clicks that they can get. But it doesn't really cost much of anything to put up a pay-per-click website. So if the same thing is true, thanks to artificial intelligence, a cyber squatter can put up a more sophisticated looking, more professional looking, more misleading website without a whole lot of time or effort or expense. Thanks to artificial intelligence, we may see more of those types of websites as a result of artificial intelligence, which will, I think, unfortunately only encourage more cyber squatting.
Just as a thought as well. I mean, having been involved in many disputes in the domain name space, there's always a challenge in proving bad faith. And one of the ways that would show that there is bad faith in some ways are pay-per-click websites. But with the sophistication that AI brings to generating less simplistic pay-per-click website, but websites that look very legit on the face, with plenty of links over, providing information, which it's not easy for a panelist to decide, oh, is this factual or is it all rubbish? No one can tell, evaluate the factual merits of the content. It actually might become a tougher job for UDRP decisions to be decided against cyber squatters once they are able to hide behind legitimate looking websites.
Yeah, it's very good observation. And so it would be more difficult to become a panelist to make a decision involving AI-created website. It involves. And I'm not sure any further.
Well, another thought that occurred to me, I wonder if because of AI and the pervasiveness and the ease of using AI, is the standard being raised in that complainants now have less excuse to come up with shoddy complaints because they now have better tools that allow them to put up a good case. And not putting up a good case, I guess, would lead to maybe panels being less forgiving of the quality of the complaints. I think Doug mentioned the quality of complaints of late have been reducing. Perhaps AI will change that, or perhaps AI will raise the bar and force complainants to do a better job?
It's getting more and more challenging for everybody. So in the world of AI, I think maybe we should reimburse our panelists better because of that. Yes, so AI is a good big development that affects the practice of domain name dispute resolution a lot. And, so I think we have discussed many of our prepared topics. So one of that is domain name protection in the metaverse. Any ideas? I'm not sure whether Doug or Eugene should share. How about the domain name protection in the metaverse? Yes, maybe start by Eugene. Then.
Yeah, I think that part probably goes back to the bigger question of how to protect your IP in the metaverse, which is an interesting question but difficult to answer. Well, personally, I have not come across a so-called virtual domain name dispute in the metaverse. But I think on the broader level, for example, on the trademark prosecution side, some trademark owners are trying to register their trademarks to cover things like virtual goods services, virtual marketplaces, etc. So for domain names, I'm not aware of a virtual. I'm not sure if Doug you have anything to add, but I think the domain names I have not come across a virtual domain name dispute in the metaverse. And even today, if a virtual domain name dispute arises in the metaverse, I doubt if it's actually subject to the ICANN regime of UDRP or other existing domain name dispute resolution systems.
Maybe the metaverse will allow us to have our very first, I was about to say in person, but that's not accurate, but our first UDRP hearing where the parties are present, or whatever the terminology may be. You know, for 25 years we've had UDRP filings that have been on paper or now on electronic documents, and one of the criticisms of the UDRP is the limitation of panelists to assess the credibility of the parties or to obtain more information than is simply in the pleadings. So maybe, I'm not so sure, I don't know if it's a good idea or not, but maybe the metaverse will present us with that opportunity for a panelist to actually conduct a hearing.
I think panelists need to be paid more if they have to do that.
That's a good idea. So I think the world is getting more and more complicated. So does the decision making for UDRP. And I think we have discussed AI development from different perspectives, from the complainant's perspective and from the panelist perspective, and also from the respondent, the domain name registrant's perspective, how respondent domain name registrant can use AI create a legitimate website to confuse the panelists. So I think we have very much delivered the section. I wonder if any question from the floor in terms of AI development on domain name dispute resolution. And if not, I think we have almost there. Any further comment from our panel member, or any point that you would like to make, or concluding remarks?
I think that on Colin's earlier point about whether the availability of AI tools would raise the bar of standard of domain name complaints and expectations. I think it will be it is always a welcoming development to raise the quality of the complaint. I don't think the availability of AI tools as such would be such a driver, but just as a separate point, especially in the reverse domain name hijacking context, when a party is represented by lawyers, then the expectation is on them is higher. And we've seen decisions and comments on reverse domain hijacking that if a party, if the complainant is represented by lawyers and they submitted a complaint which obviously would fail on either all three of the elements or one or two of these elements, then the panelists would be more ready to find reverse domain hijacking against the complainant, as opposed to a case where the complainant is not legally represented.
Yeah, thank you, Eugene.
I don't want to come across as overly pessimistic about artificial intelligence. I do think the possibilities are there. To respond to a question that was asked about when that video was created, when those examples were conducted, they were a number of months ago. And this is a very fast-moving area, obviously. So whether I would receive those same results today as I did a few months ago, I don't know. That's why I say that I'm hopeful that the technology will improve, that we can use artificial intelligence, whether we're representing complainants, representing respondents, or issuing decisions, that these tools will they have the possibility of increasing the quality of our work, of reducing the amount of time spent on our work. But I just don't think that we're there yet. It would be wonderful if that is where we get to.
I would say I have a less pessimistic view, although it's not overly optimistic. I foresee a day will come. I don't know when it will be, but it's certainly not 10 years in the waiting, much sooner, where you have artificially intelligence-aided domain name registrations that are cyber squatting, artificially intelligent-aided complaints being filed, artificially intelligence-aided case management being attended to for verification, validation, and process management, artificially intelligent aid for panelists to derive a much more robust decision, all aided by artificial intelligence, certainly not supplanting the roles and responsibilities of the individual players. So I foresee that happening. As to when, I guess we'll know soon enough. It probably happened during our living days on this earth.
Okay, and
I guess I'll add, again, at the risk of sounding too cynical or too pessimistic, but to look at some perhaps analogies. Here in the United States, just today, I believe, Tesla, the automobile company, is issuing a recall for approximately all 2 million of its cars that are on the road because of problems with the so-called self-driving technology, the autopilot feature. The company that was trying to provide driverless taxi services in the state of California has significantly retreated as a result of a number of accidents and other challenges there. So I think in some ways you can say that this is the price of progress. If you don't take some risks, you're not going to gain much of anything. On the other hand, there's some real dangers in the meantime until the technology is perfected. So yes, I agree, and I hope that the use of artificial technology will help all of us in the area of domain name disputes. I, again, just don't think that we're there today at the end of 2023.
Oh, yes, thank you. We got 2 questions here, and I'm not sure whether we have responded or not. I think one question is about. Yes, the question on The question: do you believe that taking into account current state of development in the AI field, it is better not to use AI for UDRP complaint, respondent, and panelist? Do we agree or have any dissenting on that?
May I?
Yes, Carol.
I can't answer this question because I think it comes down to who's the user and the capability of the user. It's just like saying, should I use Microsoft Word to type my complaint or to type my decision? Well, it all depends on whether as a user you know how to use Microsoft Word, whether you know the functions, you know how to control it suitably so that it will produce the outcome you need, and you are smart enough and responsible enough to review what you generate with Microsoft Word for the product that you had intended it to achieve. And I see artificial intelligence as a tool. And so the user of the tool has a responsibility over the tool he chooses to use. So I think it's okay if you're the right person for the tool.
Okay.
Yeah, I think if you know how the tool works and what the limitations of the tool are. Unfortunately, I think maybe my biggest concern is those who know the least about this area of the law, the UDRP and domain name disputes, may be those who are the most likely to experiment with using artificial intelligence to assist in the process. And therefore, they're not going to recognize the mistakes generated by some of these AI tools. I will say, I've been doing this work for over 25 years. Other than the little experiments that I showed in the video, I've not used any AI tools in representing complainants, in representing respondents, as I occasionally do, or in drafting decisions as a panelist. Maybe that's old-fashioned, and maybe because I know the law and because I know the limitations of the tool, I should be using it. But frankly, I sort of feel like I know how to do it the old-fashioned way, and it works well for me. Again, maybe next year I'll be doing it differently.
Okay. So how about Eugene? Do you like to use AI or not to use AI?
I agree with that and what Doug and Kanan said. I think as a reference, I would say it is probably acceptable. Take Doug's questions asked in the video, right? And name top 5 cases on a particular point, whether it's okay. Well, top 5 cases on subsequent addition of a domain name to the proceedings. If you ask AI this question, is no different than you typing this question on a search machine, search engine, and then it would come up with something. And then whether those 5 cases are actually good authorities, of course, you have to analyze it. But to me, it's okay to ask AI this type of questions, and then you look at what AI, what answers AI give you, and then they might or may not be correct. It's just that you have to be careful. You have to add an extra bit of analysis. But if what you are thinking is you ask a question to the AI tools and then you just copy and paste it to your arguments or decisions, and I would think that's very risky.
Okay. Yeah. Thank you. So another question is quite similar. It is a question to Doug, and it says great insight. Recently, judges in England were warned about using AI. I would like to ask Doug if he sees any difference in the dangers decision makers, such as UDRP panelists or arbitrator, faces in using AI that is different from the advocate face, and some tips on safe way AI can help decision makers. So that's a question intended to Doug.
I don't know that I have any better answers than any of us who are speaking. But I would say, at this point, I think it could be a useful tool in the toolkit, but it should not be the only research or drafting tool that is used. You know, I think as a panelist, we should be among the most informed about the UDRP, and so therefore, I am not one of those who is a vocal critic of UDRP panelists. I think for the most part, UDRP panelists take their roles very seriously and conduct themselves very professionally, and for the most part, issue very appropriate decisions. Are there some exceptions to that? Of course. But I think for the most part, UDRP panelists are doing a good job, have done a good job for many, many years without the use of artificial intelligence. And if it can be used to help supplement what we're doing, then perhaps that would be appropriate so long as we all recognize the limitations.
Okay, thank you.
One other quick point that occurred to me that is not directly relevant to the question, but that I was thinking about is, these the way that AI tools learn, so to speak, is by digesting other information. UDRP decisions are published because ICANN requires the ADNDRC and all of the UDRP providers to publish their decisions. But the UDRP filings themselves, the complaints and the responses, for example, as well as any other filings that may arise during the course of the UDRP proceeding, those documents are not publicly available documents. The only people who see those documents are the parties who drafted them, the opposing parties, and the UDRP service providers and the panelists. So there's a limited library, so to speak, it occurs to me, of material out there that's actually helpful to complainants and respondents. Yes, the decisions are what are often cited and should be cited in complaints and responses. But I've seen so many complaints and responses where the parties simply don't know how to go about drafting one. So raise one question as to whether there should be some library in which parties voluntarily contribute their filings. I think many parties probably would not agree to that, but perhaps some would. That would increase the ability of these AI tools to learn better than they are right now.
Doug, that's a very interesting part because it triggered another point in my thought, which was in order for artificial intelligence systems that are open to the public to use, to learn things, information must be uploaded. But content that might be found in complaints, responses to complaints, which are even rarer, they might be privileged. I don't know. They might be privileged depending on the jurisdiction you're from, and confidential as such. And so whether loading such information into a library, which is out there, exposed to some artificial intelligence controlled by some other third party, might itself not be a very professionally correct thing to do. Just throwing it out there.
No, it's a very valid point. And I don't know what the answer is, but I think the reason why, despite tens of thousands of UDRP decisions over the past 25 years almost, why parties don't draft higher quality documents is because they don't know what they look like. If you haven't done this before, you don't know how to do it, and there's no easy place to go learn from. So whether artificial intelligence can somehow help teach people more about the UDRP or not, I don't know. But I certainly share your concerns about confidentiality and privilege and so forth in the documents.
Okay, thank you. Actually, we got one more question on the blockchain domains and whether you are our member familiar or not. The question says, may I propose a question that slightly deviates from DNS system, but still relevant to our topic? Are you aware of any ongoing conversations regarding the expansion of UDRP standard procedure to encompass blockchain domains like .eth, the Ethereum domains. I'm not sure whether any of you heard about the blockchain .eth domain.
Yeah, I'm familiar with
Yep.
some of those issues. I'm not familiar with anybody trying to adopt the UDRP doing it, but I don't know whether that is going on or not.
I see. I think this is any question?
Well, I have an observation about that. Essentially, when you're talking about these so-called Web3 domains, they are based off Web2, Web1 domains. They essentially just generate top levels that now have second levels, third levels that are blockchained or subject to a blockchain system of record keeping and transactional management. And as such, as many of you who are familiar with the DNS system would know, once a certain higher level domain has been delegated to an authority to manage the lower level, all right, let's look from the left to the right. If something on the right has been delegated, the person with control of the right-sided domain can decide everything he or she wants to do with the next level on the left, and so on as you delegate the right side. I mean, that's how the DNS system works, and that's how it's been fixed up by ICANN. So it is really up to the delegated authority to decide what kind of system they want to implement. And we heard about the DAO earlier, which was a very interesting sharing. And because these are privately controlled, however much I take the concept of democratization with a pinch of salt here. That's my personal view. But however much there is an idea of democratization in the sense that everything under that generic top-level domain is now democratized internally within that, it is still a domain on the DNS. And how that control is to be placed under a UDRP-like policy must be on the basis of the submission of the delegated authority to that system. But I've not heard of any one of them wanting to do that. And I'll be very suspicious if they want to, because I think they will lose control of it.
Yeah, thank you for Karen for the very insightful view. I mean, really depends on the administrator or the delegator. And I believe that UDRP is a very successful model for speedy and effective resolution for domain name dispute that can be borrowed by other area. I believe that, but we won't have time to explore further. Maybe I just one more time to ask the floor if the current any question from the floor. If not, may I invite all of you to join me to thank our panel member for the excellent presentation and views. Thank you. And thank you for Doug for joining us from a long way online.
Thank you.
Thank you, Eugene. Thank you, Carla. Thank you very much.
Thank you.
Thank you to our panel of speakers and moderator for the insightful session. Now may I kindly request the speakers who are here with us today to remain on stage. We would like to invite the director of the AIAC, Dato' Sundra Raju, to come up on stage to present a token of appreciation to our speakers. Thank you, Dato, and thank you to our speakers. Without further ado, let us proceed to the final session of the day, entitled Enhancing Digital Security, Trends and Importance of Domain Name Registration. For this session, I would like to call upon our moderator, Mr. Timothy Xiao, to come up on stage to kickstart this session. Joining him on stage is Ms. Hemalata Ramalu from Screen, and joining us virtually are Mr. Stanley Lai, as well as Ho Yun Nam. Thank you.
Good afternoon. Welcome to the last session for the day. The topic is Enhancing Digital Security, Current Trends and Importance of Domain Name Registration. We are very privileged to have 3 speakers from 3 different jurisdictions. Allow me to introduce the speakers. First, we have Dr. Stanley Lai from Singapore. He's a senior counsel and partner of the law firm Allen & Gladhill. He's the current chairman of the Intellectual Property Office of Singapore and has numerous awards, too many to mention, all of them. He was listed as Asian Legal Business Top 15 IP Lawyers in Asia, and also the IP Lawyer of the Year recently by the Legal 500 Southeast Asia. Dr. Lai will be speaking on cybersecurity issues and current trends, and he will also give an overview of domain name security measures, and also the domain name filing strategy, registration strategy, should that overlap or mirror your trademark portfolio. He will also do an overview of data protection laws. Our next speaker is from Korea. He is Mr. Ho Yun Nam, the lead partner at Barun IP and Law. He's the president of FICPI Seoul, Korea, and an arbitrator panelist of numerous arbitration centers and organizations around the world. He serves as the chairman of the Korea Internet Address Dispute Resolution Committee. He has extensive experience in domain name disputes with nearly 1,200 decisions. Very impressive. Mr. Ho Nam has lectured at various universities as well and spoken more than 50 times at international conferences around the world. He hosted weekly TV programs and has written 8 books. Mr. Ho Yun will be speaking on sharing his experience on making decisions regarding commercial rights in unregistered trademarks against public interest. So he will do some case studies and share with us some of the decisions that he has made. Our last speaker is next to me. She's Ms. Hemalata Parasa Ramalu, a partner from Screen. Hema has a science and law degree, quite unusual. Her areas of practice include advisory, litigation, alternate dispute resolution, with a focus on IP and product liability. She is a regular contributor to LexisNexis Malaysia and a contributing author for the Malaysian chapter of the Russell Clark and Howe on Industrial Designs. She is also a panelist on domain name dispute resolution at the AIAC. So we're going to start off with Hema. She's going to touch on, not touch on, I think go into great detail on commercial rights of the complainant against the free speech rights. When is a person, a cyber squatter, exercising free speech rights to criticize or to so the balancing of the rights against legitimate commercial rights against free speech rights. So without any delay, Hema, perhaps you could do your presentation.
No, this is a TV remote. Distinguished guests, ladies and gentlemen, good evening, and welcome to today's talk, The Dichotomy Between the Commercial Rights of a Complainant and the Free Speech Rights of a Respondent in a Domain Name Dispute. Now, I know that we are the last panel in between the networking session, which is towards the end of the day, and I am very aware of that. So we will try to keep it as brief as possible and try to take you through some interesting cases, hopefully to excite you and keep you awake until the end of the evening. Like I think our previous colleagues have said, the UDRP proceedings and the domain name disputes is a very wide and open subject. And the topic that I am going to touch on in itself is a wide one, and there are several cases to be discussed. I will be touching on the history and development of the cases, the old approaches that have been dealt with in the past. And I will leave my colleagues, especially Mr. Ho Yun Nam, to take you into the present and into the future correspondingly. And although my session is focused on these key areas, in order to understand these areas, we would have to revisit some key and fundamental principles about the UDRP and its overall purpose and objective, and how those objectives and overall purpose would be critical here in Malaysia. Now, the UDRP, being the brainchild of WIPO, has since seen versions in various jurisdictions. As a globally recognized best practice, it is also the basis for a significant number of country code top-level domain dispute resolution policies. The MyDRP is one of them, and although there are differences, the differences are really very tenuous. Adopted by ICANN as a much-needed standardized alternative to multi-jurisdictional court litigation, the UDRP provides itself, the UDRP prides itself in providing an efficient remedy for brand owners and predictability for domainers. It fosters consumer protection for end users and acts as a safe harbor for DNS registration authorities. Since the MyDRP is framed on the UDRP, potentially any arguments made in UDRP proceedings, particularly in a jurisdiction which applies common law, would also be of use to domain name disputes in this country. And indeed, there has been development in this country where a domain name dispute or a UDRP proceeding has been referred to a court of this country, which is all very exciting news, and perhaps I will address that towards the end of this talk. And on that note, we will look into some of the outcomes which might be worthy to take note of in terms of addressing the balance between commercial rights of a complainant and the free speech rights of a respondent in these disputes. Now, earlier today, you might have already gone through and discussed the first element known as the threshold element. This is where, when the complainant files a complaint, he has to prove whether the domain name in dispute is identical or confusingly similar with the claimant's trademark. Historically, they had differing decisions in different jurisdictions, which might suggest that different approaches have been taken depending on whether a panel is impaneled in the United Kingdom or whether they are impaneled in the United States of America. Paragraph 5.2 of the MyDRP incidentally has adopted this threshold requirement, and therefore for a MyDRP dispute in this country, locally, a complainant would have to fulfill this same criteria, which is also known as a prima facie case. In Walmart Stores versus Richard MacLeod, the domain name in dispute was walmartsucks.com. Interestingly, although the complainant had not produced any evidence of potential confusion, the panel decided that the policy was adopted to prevent the extortionate behavior commonly known as cyber squatting, in which parties registered domain names in which major trademark owners had a particular interest in order to extort money from those trademark owners. As the respondent in this case intended to sell the domain name for a sum higher than the litigation cost, they found the complainant to have satisfied locus standi and went on to make a finding of transfer of the domain name. This was a departure in terms of the test that is generally applied, which involves a straightforward visual comparison. Generally, for a domain name dispute, the threshold only requires you to look at the trademark and the domain name and see whether there is an adoption of the trademark. But in this particular case, the panel went beyond that. They took a more holistic approach. In Aster Group, which is a British case, decided by a panel in the United Kingdom, the panel there was required to deliberate over the domain name astersucks.net. The panel construed confusingly similar as meaning that the domain name, by reason of its similarity with the complainant's trademark, must likely lead to a substantial, not insignificant, level of confusion among Internet users. It also interpreted confusing as a confusion in the minds of Internet users that the domain name is or may very well be a domain name belonging to the complainant or licensed by the complainant. The panel decided that the fact that confusion may have arisen from the linking of the respondent's site astersucks.net to the complainant's site aster.co.uk is support for the proposition that the respondent has made confusing use of the domain name. It is not support for the proposition that the domain name is confusingly similar to the complainant's trademark. The panel acknowledged that the grotesque behavior of the respondents was there, but found that the abuse in question was outside the scope of the policy when used in relation to a domain name which is not identical or confusingly similar to the complainant's trademark. The panel contemplating taking a broad brush approach on the basis that there had been a clear abuse in relation to a domain name featuring a trademark of the complainant, but the panel took the view that this could be dangerous because the policy is meant to be narrow in scope and is not intended to cover all abuses. Now, after the establishment of top-level domain names which might incur a pejorative term these days, there has now been increasingly more holistic approach that is being used, obviously. While the general approach has been to disregard the TLD itself in establishing whether there is confusing similarity, these days panels consider the use of the confusing similarity where that domain name is a combination of a trademark and the pejorative term, either on its own or as a TLD, and the panels have observed that if the approach in the Aster decision is taken, then everybody would obviously want to circumvent the standing issue by simply appending a sucks variation at the end, and then they will fall foul of the threshold requirement required under the UDRP. Given the two different approaches taken in these two different panels, I think we all will realize that slowly panels have moved into the Walmart sort of approach in deciding cases these days. Moving on from the sucks cases. Now, the .sucks top-level domain name has also raised interesting issues when it came to the determination of the second UDRP element, where a fair use defense is often cited. In general, a composition of a trademark plus an additional term cannot constitute fair use if it effectively impersonates or suggests sponsorship or endorsement by the trademark owner. While prima facie a trademark appending a pejorative term suggests no association, thereby not satisfying the second element, panels have looked at other circumstances to see whether this is negatived. The Walmart Sachs decisions are important for the UDRP jurisprudence, as they have been useful in the development of the argument that sites such as these are genuine, non-commercial sites set up as a criticism website, and therefore parties, particularly those in the United States, are entitled under the First Amendment principles to voice their criticism in any manner permitted. A legitimate interest is therefore quite easily found in these First Amendment cases. Having said this, if other behavior is established, such as redirections to the complainant's website, commercial or pay-per-click links or references to indicate that the respondent intends to unfairly profit from the complainant's reputation, then this would obviously mitigate or work against them. Similarly, if the respondent engages in cyberflight or provides false contact information or engages in a pattern of trademark abusive domain name registrations, then these are all considered under the second UDRP element as well. Now we will move on to the fair use defense that a lot of respondents often cite in MyDRP proceedings or UDRP proceedings. The first sort of or type of fair use defense that is often used are the type of defense that is known as a criticism side defense. And one such popular criticism side case is Walmart Stores versus Domains case number 2013, where there were several disputed domain names that incorporated the word Walmart. It was Really Walmart, ReallyWalmart.info, ReallyWalmart.com, ReallyWalmart.net, and so forth, which are all registered with GoDaddy. The disputed domain names had a prominent banner reading Really Walmart right at the top, and it displayed the complainant's marks and contained information, testimonials, brief video segments, and blogs about labor practices and the complainant's alleged mistreatment of its workers. So the site contained a notice at the bottom of the page stating, "This website is sponsored by the United Food and Commercial Workers International Union. It is merely a parody of the website The Real Walmart and is in no way affiliated with Walmart." So we are going to look at this case and see whether, even with these endorsements at the bottom and all these qualifications, what did the panel decide in this case? Apart from that disclaimer, there was also a legal disclaimer that UFCW and Walmart have the purpose of helping Walmart employees as individuals or groups in their dealings with Walmart over rights and standards, and their efforts to have Walmart publicly commit to adhering to labor rights and standards was meant to help Walmart employees. So in this UDRP proceeding, the complainant complained that the respondent had no rights or legitimate interests in respect of the disputed domain names, obviously, because the respondent was not in any way affiliated or associated with the complainant and therefore did not have authority to use the Walmart trademarks. The complainant also alleged that despite the possibility of fair use available based upon the respondent's rights to free speech, the respondent unfortunately chose very confusingly similar domain names that signal the authenticity of his website rather than indicating the respondent's website is not associated with the complainant. In these proceedings, the respondent did not put any response. So the panel was left with only the record that was filed by the complainant, as well as all other documents available in the record. And the record reflected use of the disputed domain names in connection with a forum for criticism and labor organizing related to the business conducted by the complainant. The panel there acknowledged that while fair use was found in some cases, because the panel concluded that the respondent's choice to add certain words to the trademark itself alerts internet users that the web page is not that of the complainant. But they went on to comment that the principle of free speech on the internet does not go so far under the policy as to allow confusion experienced by internet users to be dispelled only upon reviewing the content critically. So in other words, the panel said, look, if I were to click really Walmart, what is the first impression that I'm going to get? So they said, look, I have to go through and critically analyze the whole page, and it's only right at the bottom that you're dispelling me that this has got nothing to do with the complainant. But if you look at a page on an overall basis, it appears to suggest from the way it is dressed up, the way, the Walmart trademark is used, that it is in some form or way or shape associated with Walmart. So that can't be the way that you should go about doing this. You should, in fact, try to look completely different in order to come within the fair use defense. The panel unanimously agreed with the complainant that the respondent's choice of the disputed domain names was not fair use. And to compound confusion, they added the word really Walmart. And they adapted on the website the disputed domain names, the texture, elements, style that all looked like Walmart's own website, which is the real Walmart. And in doing so, the panel decided in favor of the complainant and had the really Walmart links deleted. From that case, we will now move on to the fan site cases. There is also another form of fair use defense that is often used in these proceedings, which is the fan site defense. And these are wonderful cases to actually read, because this is when you read your Sofia Vergara cases and your Jennifer Lopez cases, where there are tons of fans who set up websites dedicated to a celebrity that they like. But the case that I'm going to look at is the case of the Honorable Ron Paul versus DN Capital. Now, in this case, the First Amendment argument that has been used in the criticized site defense was also used in this case under the second UDRP element. The claimant here was a former US Congressman, Ron Paul, the Honorable Ron Paul. He was a very well-known political commentator in the US. He served in the U.S. in the House of Representatives during different periods in Texas. He was also a 3-time candidate for the President of the United States. He was a leading spokesperson in the political field for issues such as limited government, low taxes, free markets. He authored 7 books, 3 of which had been New York Times bestsellers. Now, the complaint there, which was lodged by Ron Paul, was denied for various reasons by the panel there, including that by submitting evidence that the domain name was being used in connection with a free speech fan website, the respondent had effectively foreclosed the complainant's ability to prove bad faith. The panel found that, as a general proposition, the same facts establishing fair use and the exercise of free speech negated a finding of bad faith intent. In this case, there was no attempt to make any commercial gain or pay-per-click advertisements by the respondent in this case. It was being used purely for no other reason other than being used as a fan site. In fact, in this case, the respondent appealed to the complainant. He said that the main reason they had obtained the domain name was so that the complainant would use that website, ronpaul.com, which they had registered, as opposed to the one the complainant himself was using, which was ronpaulshomepage.com. They had actually approached Ron Paul and said, look, please don't use ronpaulshomepage.com. Please use our site, which we registered for you, ronpaul.com. It is more direct and attributable to you. And in fact, the respondent was prepared to offer the website to the complainant for free with no strings attached. But in spite of all these offers had been made, unfortunately, and in an inadvised manner, the complainant there went and lodged a UDRP proceeding. And instead of finding in favor of the complainant there, the panel there made a finding of reverse domain name hijacking. In other words, that Ron Paul had been guilty of trying to reverse domain name or hijack it from the actual respondent, which is very, very interesting. Now, other than the fan site use cases, what are the other types of conduct that panels look at? And I'm sure you would have already heard the terms, as I was sitting there and listening, you would have heard terms like parked pages, pay-per-click links. Now, following on from the cases that we have just discussed and other fan site cases, like I said, like the Sofia Vergara cases, the JLo cases, it is interesting to know how much weight the existence of pages that reroute to other sites which do attract commercial gain or pay-per-click links are required for the determination as to whether the respondent has any rights or legitimate interest in the domain name. In other words, panels want to know, look, are you setting up these sites genuinely as a fan, or are you trying to make a profit out of this celebrity's name? If the respondent makes great efforts to suppress the appearance of pay-per-click advertising, then this would also work greatly in advantage of the respondent. In other words, if they show efforts to not make any profit or commercial gain, that would act in the interest of the respondent. The nominative use or resellers, distributors, or service providers agreement is, I beg your pardon, in respect of the nominative use cases, which is the third thing I would like to touch on, it is impressive to note that there is the Okidata case or the Okidata test, which is still very much relevant till today and is used consistently, which makes the outcome of similar cases very predictable. There has been no major change in this regard under the current WIPO jurisprudence, and if the domain site accurately disclosed the registrant's relationship with the trademark owner and the services that it provides, they will be permitted to continue with the usage of the disputed domain name. In short, I believe, if I'm not mistaken, the Okidata cases are the cases where, for example, there's a licensee in this country and he obtains a license from, say, a proprietor of a mark abroad, and in order to sort of run their business in this country, they go and register a domain name, and they continue to use that domain name for a prolonged period of time in this country. So the Okidata test essentially says that, look, so long as the domain site accurately shows what your relationship is with the trademark owner, then you're permitted to use your domain name. And this has been the consistent approach and finding across all panel decisions. We now turn to the third and final UDRP element. Apart the cases where there has been reckless warehousing and trafficking behavior, panels have, on the other hand of the spectrum, been able to find evidence of bad faith even in cases where the site has been primarily one which was used as a criticism or fan site. In the earlier Rayleigh Walmart case that was discussed, the panel there found that disruption of business and the use of confusingly similar domain names was evidence of bad faith. Panels in other proceedings involving non-commercial protest sites have found that a lack of sponsorship affiliation with the mark holder could not amount to a bad faith. However, those proceedings involved mostly neutral domain names, none of which was so strong in suggesting a relationship with the rights holder as the disputed domain names in the Rayleigh Walmart cases. So the panel appraised the website holistically and found that the use of language, trademarks, style, texture on the website to which the disputed domain name routes that imitated the complainant's website was misleading, and that it compounded confusion, and that the language of the website did not clearly and immediately dispel that confusion. Now, this is an interesting development and reinforces the position that the circumstances which may be construed as bad faith are not closed. Now, what are the type of other bad faith factors that panels look at? Among other factors that panels have accepted as evidence of bad faith include, as discussed earlier, the type of the top-level domain name that is used, whether there is a passive holding or non-use of the domain name, that the website is being used for purposes other than to host a website, for example, for phishing, identity theft, and malware distribution, whether there has been any legitimate use of robots.txt, and whether the provision of false information underlying a privacy or proxy service, or the layering of a privacy or proxy services to avoid liability as evidence of bad faith. As for privacy or proxy services, while its mere existence in itself is not evidence of bad faith, given that this might be put in place for practical and privacy reasons, any conduct which supports an inference of bad faith is generally not entertained. So what can be done in instances where there is an imbalance, and you know for a fact that bad faith can be established, and these parties are aggrieved by those instances of bad faith? In general, there are three remedies available. First of all, you have your UDRP, your URS, and court proceedings. Now, this is where I was talking to you about the earlier case, the earlier Malaysian case that has recently come up, which I must say that Malaysian case alone requires a separate discussion. It warrants a separate discussion because it is very interesting. But before going into the Malaysian case, I would like to go into the British case of British Telecommunications PLC and another versus 1 in a Million Limited, which I have cited there. In this case, the plaintiff in each of the 5 actions was a well-known company possessing registered trademarks. It was Marks and Spencer's, most of which incorporated the company's name, and the use of which was that the plaintiffs owned substantial goodwill attaching to them. There was no dispute to it. Marks and Spencer's is a very popular trademark. Now, the defendants there, 1 in a million, were dealers in internet domain names who registered names and sold them to potential users, and it was accepted that in each case they had registered domain names comprising the name or trademark of the plaintiff. So they used the words Marks and Spencer. The plaintiffs sought injunctive relief, alleged passing off and infringement of their trademarks, and applied for summary judgment. The judge there granted the plaintiffs final injunctions quia timmet, holding that although mere registration of a deceptive company name or internet domain name might not be passing off, but it was sufficient for the purpose of granting the injunction that was going on and which was calculated to infringe the plaintiff's rights in the future. And on appeal to the Court of Appeal, this decision was upheld, which prohibited the defendants from using the domain name in the form they had registered. So what does this mean? Now, the courts have to be very clear, just like all alternative dispute resolution proceedings, whether you have your construction matters or all other forms of disputes that become, that fall under the purview of arbitration, for example. Now, the court's role, which is very significant, is basically it works hand in hand with alternative dispute resolution. So there are forms of relief where parties will obviously run to the court to ask for remedy or assistance in aid to alternative dispute resolution proceedings. So that is what exactly the parties here did. They ran to court because they wanted injunctive relief. Perhaps at that time, bear in mind, this is a 1998 case, very early case, where you could run to court to ask for injunctive relief. It is a form of relief that only the court can provide in aid, but they do not interfere with the domain name dispute proceedings if those are going on. Now, there is the recent Malaysian case of Junzi Wang versus, I beg your pardon, there is a recent Malaysian case of Junzi Wang and Red Bull vitamin drink versus TC Pharmaceutical Industries Company Limited. And like I said, this requires a separate discussion, and I hope the AIC has will give us an opportunity for us to discuss this separately. In short, I believe that the court did not take the opportunity to conclusively say this and set out what is its role and what it has to play when it comes to UDRP proceedings or domain name dispute proceedings. Because injunctive relief was not sought there. I'm not sure why, because had they sought there, they should have obviously gotten it, because the court has jurisdiction to do that. But in that case, the court did not go into that aspect and conclusively set out what its role was. But, however, that case is critical and important because in that case, effectively, the company there, the plaintiffs, Junzi Wang and Red Bull, were aggrieved by a UDRP decision that was granted in China, which was against them. So they filed an action in court in Malaysia to ask the Malaysian court here to reverse the decision, or it was an appeal to reverse the decision of the UDRP. The High Court in this case correctly stated that, look, we do not have jurisdiction to listen to this case in this country because you must understand that under the UDRP, or for that matter locally the MyDRP, it is subject to a contract where the complainant, or rather the registrant, enters with whichever provider is providing the service for that particular domain. So under that agreement, they have agreed that if there are any disputes, the only avenue that they have is they must refer the dispute to the UDRP, which is what happened there. There was a dispute, so the dispute was brought to the UDRP. But because the UDRP falls outside of the jurisdiction of this court, and there is no particular act in any country, including in this country, which says, look, if you're aggrieved by a UDRP decision or a MyDRP decision, then there are extraordinary cases where you can actually review these decisions. Just like in this country, you have your Arbitration Act, you have your Adjudication Act, where there are very small and brief instances where the court can sort of intervene to assist and aid these alternative dispute resolution outcomes or decisions. There is no similar act in this country. I doubt there is any similar act in any country. Therefore, a form of appeal from a UDRP decision or a MyDRP decision is impossible. You cannot appeal it. So what does this mean? This means the UDRP decision and the URS decision or a MyDRP decision is a very, very powerful one. Once a decision is rendered by a UDRP panel, it is final. There is no further appeal from it. So and it's very quick, it can be resolved within a few months, unlike court, which will take a year, maybe a year and a half. So and it's very inexpensive. UDRP proceedings and MyDRP proceedings are very inexpensive. So it is certainly something preferable that private limited companies or parties who are aggrieved or trademark holders should try to use in order to find a quick and effective remedy for their companies. So going back to the URS and UDRP, now what is the similarity, what's the difference? So before I go into specifics, I would like to just briefly touch on the relationship between the UDRP and the URS, which was created by ICANN, of course, but WIPO is not a provider of the URS. It is a provider for UDRP. The UDRP and the URS are not specifically linked together, but ICANN, although there is a resemblance in terms of the requirements, the biggest difference, obviously, between these two systems is in the types of remedies each provides. The UDRP allows for transfers, deletions, and suspensions, whereas the URS only has a limited power to offer a temporary domain name suspension. There are also differences in approaches and procedure. There are limited pleadings contemplated under the URS. Given the fact that a resolution is quickly required, it is cheap, and that the remedy required is a temporary suspension only, the UDRP is open to a more significant amount of pleadings and responses. Other than that, the standard of proof is also different. The UDRP requires proof on a balance of probabilities. URS requires the complainant to demonstrate by clear and convincing evidence. Because of the speed each of the decisions are required to be delivered, seldom do you find a reasoning given or required in a URS proceeding. You are not required to provide reasoning for a URS proceeding. As such, a URS and UDRP proceeding can be initiated simultaneously, and a filing party may choose to withdraw one of the proceedings, whichever way which decision goes, and depending on which remedy it desires. And it has to be noted that the panel in each may come to completely conflicting findings, and nothing may be construed if those two findings are completely incongruous with each other. However, given that the URS offers only a remedy of temporary suspension, complainants have, after a URS finding has been delivered, then filed a UDRP proceeding to obtain a broader remedy, which is what happened in the case of Yves Saint Laurent versus Kita Kongsan Satien, case number 2016. The complainant, obviously, is a French luxury fashion house founded in 1961 and the owner of the word YSL in various international classes. These trademarks are well known due to the complainant's advertising, marketing campaigns, together with the luxury and high-end quality of their products, including perfumes, clothing, handbags. The respondent, on the other hand, was an individual with an address in Bangkok and the owner of YSL.club and Saint Laurent.club. The complainant submitted a complaint in respect of the disputed domain names under the URS, to which the respondent did not answer. So the examiner appointed under the URS determined that the complainant had demonstrated all three elements of the URS by a standard of clear and convincing evidence, and ordered that each of the disputed domain names be suspended for the duration of their registration. The complainant then attempted to resolve the suspended websites further to the determination under the URS to be transferred to the complainant through a UDRP proceeding. The complainant argued that prior to the URS determination and consequent suspension of the disputed domain names, both of the disputed domain names had been used in connection with the publication of sponsored listings, which included links to the complainant's products. And at least in one case, the competitors' products or YSL's products were shown or displayed, and therefore there was bad faith. Notwithstanding the earlier URS ruling, the UDRP panel on its own came to the determination that it could identify no possible good faith motivation on the respondent's part why he wanted to register YSL.club or Saint Laurent.club, as there was no prior use of that or by him. For complainants further, it went on to find that it did not consider that the web pages associated with each of the disputed domain name in their suspended incarnation, each stating that the disputed domain name has been taken down pursuant to the URS, so there was no compliance of the URS. It was the respondent's use prior to any such suspension that was the focus, namely during the period when the respondent was in a position to exercise control over the disputed domain names, that was important. So as you can see, in this case, ultimately the complainant completely and absolutely was able to achieve what they wanted to do. which was go through the URS proceedings and get a very quick relief of suspension, which is within 3 months. And then they got an even better determination of complete deletion through the UDRP panel, which is ultimately what they wanted and the only thing that they wanted. So these remedies of URS and UDRP, or these proceedings which are available, are very, very powerful. They're very, very quick. They completely conclude the matter, because for a lot of these situations, a lot of the business that these respondents put up entirely rely on website. And as you would have noticed, the post-pandemic or during the pandemic, sale through or sale online was the most critical way how people could actually sell a lot of things. So can you imagine when or if at all there is a further suspension a further lockdown, and if you're required to only sell things online, and if that particular domain name is completely deleted, this will effectively ruin your business. So in conclusion, what I would like to say is that the UDRP proceedings and MyDRP proceedings or URS proceedings are very, very powerful, and they help in getting very quick relief for complainants if that is the remedy, if they are aggrieved in the circumstances by bad faith of the respondent. That is all. Thank you. I would like to now pass on the stage back to Timothy.
Thanks, Emma. We are running a little bit behind, so we'll take questions at the end of the session. So may I now invite the next speaker, Mr. Ho Yoon Nam from Korea, to do his presentation. Ho?
Thank you very much, Kim. Thank you very much for your kind introduction. And good afternoon, distinguished audience. I'm very privileged and honored to have this wonderful opportunity to share my experience in the course of writing about 1,200 domain name cases with distinguished audience. My topic is the same.
We can see your slide, Mr. Ho.
Yeah, but I will have to make it slideshow, but it's I cannot find the slideshow. Okay. So bear with. 슬라이드쇼가 되는.
Okay, it's all good now.
Okay. Sorry. Okay. I'd like to share my experience with you in the topic of the dichotomy between the commercial rights of the complainants and speech rights of a respondent. Our life is a kind of the internal process of the seeking balance between the conflict interests. One of the hot issues is how to find out the balance between the commercial rights of the complainant and the public interests. So for the first topic, I will touch on the common rights in unregistered mark versus public interest. And for the topics for free speech rights, I'd like to talk about the Christian size, fan size, and also I'd like to add comparative advertisements. And also I will rule out if our IDNH options are functioning to counterbalance the public interest against the complainants. And sorry. It doesn't unlock. Okay, so according to wipe overview, in order to recognize the secondary meaning or the source identifier for unregistered trademark, we must show that the mark has become a distinctive identifier. But I have found some different criteria for recognizing a secondary meaning for unregistered mark. In case of the highly descriptive mark, we require very higher standards in terms of the duration and the nature of use of the mark, amount of sales, the nature and extent of advertising, and the degree of actual public. But in case of the distinctive mark or some other distinctive identifier, we don't necessarily require higher standards of the secondary meaning. And in case of the motor.com, which I wrote last month, I found this motorcontactor.com trademark, motorcontactor trademark has acquired a secondary meaning, although the amount of use is quite not so big amount, quite thin, because this motorcontactor mark is a rather distinctive identifier. And in case of the cheapp.com case, which I wrote last month, I also found a secondary meaning. But what do you think about real-time reservation.com case? The complaint has failed to establish common rights in the real-time reservation mark because the panelists noted the mark is highly descriptive given the nature of the complainant's services is minimal.
Sorry to interrupt, Mr. Ho. Your slides are not changing. Is that something you can?
Changing?
Yeah.
How about now?
No, it's still stuck.
Okay. So there is some technical problem.
Perhaps you can share your slides after the conference. You may have to make do without your slides at the moment.
화면이 안 넘어간다고. 아니 화면이 안 넘어간다고. 이거를 지우고 내리고 다시 이게 파워포인트 아닌가? 근데 왜 안 되지? 이게 엔터를 치면 이거 치우면 넘어가야겠지. 이렇게 백.
아.
이걸로.
It's still not changing. No, it's still the same slide. It's still at page, I think it's 2. No. Now it's changed.
It's changing?
Yes. It's a new slide now.
Okay, sorry. Under. Okay, I will use another file again. Sorry.
No, we've all experienced this before.
PDF file. PDF file. PDF file.
Okay. The center will be broadcasting your slides.
Now, can you see?
Yes, we can. Yeah, I think it's working now.
Yes, so this
Yeah.
is a PDF file.
Yeah.
The PPT is not working.
Okay.
Sorry.
This is better. Yeah.
Yeah. Okay. So now I would like to talk about gracesshop.com, which was came out just a week ago. To take Grace's shop, the mark Grace's shop is a distinctive. Is a highly descriptive, but the complainants submitted a lot of materials which complainant has used the mark for a longer period of time, and they expanded, used a lot of advertisement expenditures. So considering this, the panel found out the complainant has successfully established communal rights. I have noticed that very recently there's some anti-commentary against this decision, but personally I agree with the panel. And now I'd like to move on to free speech rights or the criticism sites. According to WIPO overview, where the domain name is not identical to the complainant's trademark, but it comprises the mark plus a derogatory term, such as trademark subs.dlt, panels tend to find the respondent has a legitimate interest in using the trademark. And we have the similar jurisprudence as exemplified below, but time-wise I will skip this. And also in case of the brutal hero scams.com case, the panel found is a bona fide use or legitimate non-commercial or fair use of the disputed domain name, because the website displays numerous reviews by third parties critical of complainant or its predecessor in interest, and it is fair and genuinely criticism size, so the panel found bona fide use and legitimate use. And another case for criticism size, in the case of the domain name, the southwalk.com case, it is comprised of the south, the mark southwalk, and especially it contains a word walk that in the context would be seen as a derogatory to offer what appears to be genuine in the sense that it is not a front for commercial gain. And criticism is pure, it was regarded a pure criticism of complainants' corporate policies. And another criticism side case is a robot case. The panel found for complainants, so found against the respondents. It does not constitute a bona fide use or a legitimate non-commercial or fair use, because although the respondents assert that the purpose of the disputed domain name is to amplify the LGBT2 plus issues and rights through public commentary and corporate criticism, but it in fact disputed domain names resolving website impacts mainly contains political contents on the reviewing websites. It was not considered as a bona fide use or legitimate interests. Fan sites also, according to the point of view, it's the same logic in case of the criticism sites. So the fan site must be active, genuinely non-commercial, and clearly distinct from any official complainant sites. Where a domain name which is identical to a trademark, a general right to operate a fan site does not necessarily extend to registering or using a domain name that is identical to complainant's trademark. However, we need to get our attention. Some panels applying U.S. First Amendment principle have found that even a domain name identical to a trademark used for a bona fide non-commercial fan site may support a legitimate interest. I would like to skip this part. And we have a please type libre2free.com case. The panel found respond to the rights or legitimate interests because although it pretended a fan site, in fact, is a kind of the feigned being fake fan site. So it was not, the legitimate interest was not recognized. Another case, Soldier.com case. In this case, also the panel found respondent is engaging the legitimate non-commercial use of the name, because even if consumers might be confused as to whether the site is an official site of the domain name, his former creator or his estate, the fact is that there is no showing that any of this being done is an intent for commercial gain. That's the reason of the panel. And I'd like to touch on the comparative advertisement. According to the jurisprudence of the case, compared to the Hastings.com case, the pure comparative site was recognized as the bona fide use and also legitimate interests. As contrast, in the case which I wrote last year, I found bad face registration and use because in this case, the respondents strongly argued that that's a comparative advertisement. But I found that that descriptive domain names offers competing services with complainants, as well as the comparative advertising. On this decision, there's some commentary. Most of the parts support my decision. And in one of the means to counterbalance a complainant's abuse of the rights is the option of the RDNH. But I wonder if it is a functioning right way because there's no actual sanctions such as penalties in UDRP procedures. So the actual compensation for damages should be sought by a judicial settlement. So we may need to discuss to introduce some penalties to counterbalance the abuse of the complainant's rights. This is the tendency of the reverse domain hijacking. So it is a little bit increasing the fine in case of finding IDNH. Now I'd like to move on to digital security issues. Most of the digital security issues in domain name disputes, illegal activities such as phishing and impersonating or the malware, that kind of things. So I'd like to review some cases. In the case of mailline.com case, which I wrote, I found it is not a bona fide offering of goods or services, and also I found the use of the descriptive domain name that constitutes bad-face registration and use. Because the complainant argues that respondent uses the descriptive domain name to illegally advertise and sell drugs, including some opioids and benzodiazepines. The panel, I found that respondents' use of the distributed domain name for illegal activities does not constitute a legitimate right or interest in the distributed domain name. And in case of the usual jp.com case, it's also the case which I wrote. I found a bad face registration and use, and also I didn't find a bona fide offering of goods or services because the respondents attempt to pass off as a director of complaints organization and collect third parties' sensitive information and solicit funds. Use of a distributed domain name in connection with fraud or phishing is not indicative of any rights or legitimate interests. That was my reasoning. And also another case for impersonating and phishing schemes. In case of the guest closing store case, which I wrote last month, I also found bad face registration and use, and I did find a bona fide offering of goods or services or legitimate commercial or fair use. Respondents has used the descriptive domain name to engage in a fraudulent scam, whereby it impersonates an employee or complainant in an effort to scam customers by setting up fake job interviews. Another case is a healthcare.com case, which I wrote a week ago, a very new one. I also found web-based registration and use and identified a bona fide offering of goods or services. I know that email correspondence emanating from the email formulated by the disputed domain name includes a formal job offer that displays the complainant's logo or personal information sheet displaying complainant's logo and the WP form. If completed, would allow respondent to collect delicate personal information. Another type of the illegal activities is to have the internet user to download malware. In case of the generative federal insurance.com case, which I wrote in October this year, I found also bad face registration and use and identified a bona fide offering of goods. Complainants provides a screenshot of the domain names resulting website displaying the clickable options titled Barabara, which appears to be related to a malicious software. So now I'd like to touch on a protection of privacy in case of the identity theft and redaction issues. According to our Polish paragraph 4J, all decisions under this policy will be published in the full of the internet, except when the panel determines in an exceptional case to reject portions of its decision. In the case of the DaminStraps.com case, which I wrote last year, I determined to reject as a preliminary issue because the respondent officially requested its personal information be redacted. On the contrast, in the case of the pop-up unit.com case, which I also wrote the year before, last year, I did allow to redact the respondent's name and the location because with the exception of the individual's emails denying registration of the domain names, the individual has not provided, the respondent has not provided other evidence in support of a claim of stolen identity. Further, as of the response to date, the forum has not received any formal response and proceed with the panel appointments. That's the reason why I didn't allow to redact the respondent's information. Now, to wind up, I'd like to make some suggestions. As I mentioned earlier, we have to seek endless effort to find out balance and harmony between commercial rights and public interests, considering the factual circumstances. And also all the public interests, right holders, and the consumers must be allowed not to be victims of the misuse of the domain names, because I have noticed a very strong tendency these days domain name cybersquatters misuse the domain names to collect sensitive personal information and fake job interviews and some even malware functions like that. So we need to keep monitoring the domain name issues and take immediate actions by bringing the domain dispute resolutions or to send out a letter to the registrant of the problematic dispute domain names. And in order to properly protect complainants or respondents' personal information, we need to officially request for redaction. That's it. Thank you very much. I am sorry for not conducting the smooth way. My PPT didn't work. Sorry for that. Thank you very much.
Thank you, Mr. Ho. Thank you for those very interesting examples and cases, and I hope you will be able to share your slides with the attendees. We are running a lot behind, so I hope we can all stay back and give Dr. Lai his full half an hour for his presentation. So I would like now to invite Dr. Lai to do his presentation. Thank you.
Thank you very much, Timothy, and I hope you can hear me, all of you.
Yes, we can.
I appreciate IAC for the very kind invitation to appear before you today, and I also want to thank my fellow speakers for insightful presentations, which I think in many ways makes my task a bit easier. I'm mindful of the time, but at the same time, also want to convey certain points. In the knowledge that I'm very happy to share my slides with you. So I suppose that can be made available to participants. Just a few starting points that none of what I say actually should be taken to be legal advice. I am particularly mindful of not venturing to give advice on Malaysian law. So that's a very important disclaimer. But I'm speaking, ladies and gentlemen, to the specific issue of digital security and domain name registration. And I do so in the knowledge that we are dealing with TLDs and whether generic, but at the same time also dealing with CCTLDs, which cover country code top level domains, and in the course of my presentation, I'll make some observations of that and how that seems to be also featuring a bit more now in a world that is, where the multilateral trading system has given way to greater territoriality. You will see all the different centers and registration authorities emerging, and in the course of the presentations throughout today, the audience would have been treated to ever-growing phenomena that actually a domain name registration is a very strong contractual right between end user for registrant and registration authority. And the extent to which we can undergird domain name registration with intellectual property and specifically trademark rights is what basically gives it its legitimacy and also gives rise to the different criteria for evaluating disputes. And you can see that in the points under the UDRP and even in the Singapore context, we have an SG-NIC procedure that is not dissimilar. Although I would make the observation that in the SDRP procedure, there's a slight difference from the UDRP in that the use of the language or instead of and in point 3, the bad faith requirement, it would suggest that the requirements of registration and use in bad faith are disjunctive and not conjunctive. So that's something to bear in mind. And of course, there are also slight differences with NYDRP, and you can see that in relation to the language of and or instead of and. You can see in point 2 about it. Now, speaking to the specific issue of digital security, which is really the topic of the panel, I don't have to revisit what phishing is. It is a social engineering attack, of course. We're seeing more and more of this, and phishing attack often involves domain spoofing, which is a form of phishing where an attacker impersonates a known business of the person with a fake website or email domain. And Mr. Ho Huyun's cases in his presentation are particularly germane to this point, and I think he has a wealth of experience in that area. We will also see, I think, surges And you can see some of our own published research in Singapore dealing with the rise of phishing attempts. And also, I would also draw members of the audience your attention to .ai phishing attacks. Because .ai, the domain name, has surged in popularity relating to subject matter, but at the same time, you also see the origins of .ai actually are not related to artificial intelligence. It actually stands for Anguilla, British territory in Caribbean. So not unlike .tv, some of the earlier domain name restrictions, .ai marks are also going up. And of course, there's a lot of hype that it may be beginning of the digital domain, but these are also used in phishing attacks that we have concerned. So domain security reports are there, and I would urge members of the audience to take a look at these domains. In my part of the world, in Singapore, my data protection cybersecurity practice sees a lot of ransomware attacks. Ransomware basically a form of malware designed to encrypt files on a device, but it can extend to other scourges like a denial of service. It can even be a threat to demolish or completely devastate critical information infrastructure in return for payment. And of course, for advisors like ourselves, the difficulty is always how do you manage the client to advise payment. And then in the back of your minds, you're also wondering, well, how does this trigger a notification obligation under different regimes that govern, and you know, so the domain name lawyers and practitioners also have, I think, to get into this whole area of cybersecurity and ransomware attacks are very real. And it starts with your humble domain name, which will be used for nefarious purposes. And there is, as I said, a rise in this scourge, both in terms of frequency as well as cost. Generative AI may also facilitate cyber attacks because they lower the barriers, don't they? You bypass ethical perimeters. You look, for example, in April 2023, Darktrace, company specializing in cybersecurity, reported 135% increase in novel social engineering attacks using linguistic techniques. And so these are all new fangled forms of digital, of compromises to digital security that can definitely affect this space as well. To say nothing of the fact that you have deepfakes, which in a matter of time will take over election campaigns and other similar high-profile events. So some will have domain server hijacking and poisoning is something we also want to look at, deals with the types of attacks where an attacker gains access to a DNS and replaces a legitimate website's IP address. And so you see already some of Mr. Ho's cases speaking to this. And once you accept the fake IP address, the fake IP address is then now cached by the DNS resolver. And when the user makes subsequent inquiry of the same domain, the DNS resolver will now automatically redirect them to a fake IP address. And it is a fake domain because the incorrect IP address has been cached instead of the legitimate website's IP address. And this is also known as cache poisoning. And you also have the phenomena of business email compromises, BEC scams, which Singaporeans are particularly vulnerable to this, and we've seen an increase in scams and people suffering great losses because of this. So what are some of the enhancements in terms of digital security? You have registry locks. You also have domain-based message authentication systems, which I think increasingly clients will have to be advised in this direction And it remains to be seen the extent to which the technical solution will come and match also the the dispute resolution and UDRP kind of resolution as means to end such disputes. How that interface will work, I think, is something that to the great credit of AIAC, we are actually in the cusp of trying to determine the frontiers of this emerging phenomenon. And you also have DNS security extensions, which are digital signatures that validate an IP address of a domain. And the extent to which you can do this may make it less likely that one needs to resolve and go to one of the dispute resolution policies to deal with an errant domain. And of course, a monitoring service, these are also coming up with providers such as CSC, GoDaddy, Visual. I don't have to say too much about undergirding a domain name registration strategy with trademark protection. That is almost a given. But also consider certain defensive registrations, especially if your area of endeavor traverses suffixes that may speak to that industry, for which you don't want an errant third party to come and abuse your domain name, like .ai, which I alluded to earlier. These are also defensive strategies that can be taken out of abundance of caution. Trademarks do confer territorial rights, and to that extent, under Singapore case law, you will see that ultimately to determine whether you're dealing with, you can actually define adequate cost of trade in Singapore. There must be a clear link between the website and how it targets a Singapore audience. The domain name registration strategy may find itself having to mimic this increasingly. And what I said earlier about the multilateral trading system, you will find that because most countries, especially post-pandemic, have resorted to becoming more territorial in their approach to IP rights, you will see also perhaps CCTLD registrations continuing to rise and become increasingly relevant. And being registered in key geographical locations. So I think the flexibility that's called for in every jurisdiction is to have an adequate system that resolves disputes dealing with CCTLDs as well as TLDs. It was great to see Mr. Ho's decision making extending to paragraph 4J of the UDRP, which speaks to personal data protection. And in Singapore, I can share some experience on that. Quite important to ensure that, because everything starts with a domain name when it comes to access and the collection of personal data. And so that's why I think it ties in very neatly to the subject matter of this conference, of this panel in particular. In Singapore, our data protection laws have increased the financial penalties, and you can see that these are not small sums going forward. And of course, for us, the ultimate test is whether the system integrity of a particular organization satisfies reasonable security arrangements. These three words are perhaps the most difficult words that we resolve our clients on a daily basis, that take care whether actually your system can be said to have satisfied this threshold. And practical measures can be taken, and increasingly you've got to work that in with the domain name registration strategies. In Malaysia, what's interesting is that I read that you have specified that an MOU will soon be signed between the Axiata Group as well as Cybersecurity Malaysia to strengthen Malaysia's cybersecurity and push towards this threat. So that's an interesting development. But it sounds as if you're also heading towards an escalated regime of notification as well as heightened remedies in the event of data breaches. So we watch this space. Together with that is the phenomenon of cybersecurity insurance. And I just speculate, but one of the additional grounds of seeking insurance covers for cybersecurity breaches may also extend to the cost of retrieving domain names that either have been subject of malware or have been subject of phishing or impersonation, to cover the cost of retrieval for such names to return to the domain, the original trademark or domain name owner. So these are new areas which I think insurance can also go into. Just want to conclude my presentation by talking about some of our experience in terms of SingHealth. SingHealth was, the data breach was actually a 7-month committee of inquiry following the exfiltration of patient records for 1.5 million customers in one of the bigger healthcare institutions in Singapore. And it was an advanced persistent threat that resided in servers for many years. And ultimately, it then, having learned the server architecture, would then orientate and exfiltrate data pursuing different vulnerabilities, especially servers that have not been updated and so on. These are just examples of how bad cybersecurity attacks can become. And I think with malware and with ransomware, you will see only an increase of this unless you put in reasonable security arrangements. So even if organizations were to delegate responsibility to vendors, they ultimately retain obligations and responsibilities as data controllers, and they will be held to account. So that's something to bear in mind. And even in the case of hotels, and generally when you have M&A, for example, of organizations that take over big collections of data, you could very well, and you can see that from the Marriott example, where you could actually have acquired generations of data from different systems owned by different hotels. And when you've gone through a M&A consolidation, what you may actually have done is you really increased the attack surface, and you've actually added exponentially to the cyber risk, owing to the lack or absence of protection for the different target companies. So this doesn't go into your due diligence checklist for lawyers. You will face a serious cyber hygiene issue for all these companies. So you can see how the Marriott data breach played itself out. Okay, so I just want to end by talking about the importance of domain name security measures at organizational level. I think we need to look at authentication tools like EMARC and ENSEC, and these will also help, I think, augment the protection which the current domain name dispute resolution policies actually provide over the illicit use of legitimate domain names. So I think domain name management and risk allocation is something that I think AIAC should be commended fully for dedicating a day's worth of discussion to this. And I hope that we can all move towards proactivity in terms of steps to be taken. And I'm glad that I think in my defense, Timothy, I have actually adhered to time and just gone over my 3 minutes.
Thank you very much, Dr. Lai.
I hope that's a favor to everybody.
Yes, I'm sure people are trying to avoid the traffic jam, but thank you for staying on until the end. We have some time to take questions. So should we check the chat box and see whether any questions in the chat box? before we take questions from the floor?
Sorry.
Okay, we have one question. Okay, this is a free speech against criticism UDRP cases. The emphasis is now more on the domain name composition, TM, trademark plus derogatory term like sucks, etc. TM without any derogatory term rather than its actual use. What do you think should be the correct approach in assessing a respondent's rights and interests in the free speech cases? Who would like to take this question? Mr. Ho?
Yes, I would please to answer this question. Yes, even the WIPO overview and most of the panel's decisions evaluate the case in terms of the composition of the disputed domain names. It includes the derogatory terms such as sucks or some other change in the right terms. But I'd like to more seriously consider the actual contents of the respondents' websites. Regardless of the composition of the disputed domain name, even in the case of the identical mark, if the website really contains the genuine and fair criticism, or in case of the fan sites, purely genuine and real fan sites, then we should find a legitimate interest or the use of the dispute domain name. That's my view. Thank you.
Thank you. Anything to add? Okay. There are no more questions in the chat box. Questions from the floor? Yes, I have someone raise his hand.
Yeah. So I have two questions for the panelists, but probably more for Ms. Hemlata. So you mentioned how in different jurisdictions, different panels, the rulings are likely, not likely, but there is a chance that they can be different. And you gave us the example of the .sucks, the way Walmart.sucks was handled in the US, I believe, and I forget the other name in England, where it was seen differently. Now, given that a claimant is free to choose any panel or any jurisdiction, is this likely to give, or have you heard of forum shopping, or rather panel shopping, where a claimant will go to a panel which is more likely to rule in his favor rather than another panel which is not? Yeah.
Can you hear me?
Yes.
Okay. I think what I said was, I think historically there was perhaps a difference in how
But
panels
even now there is a possibility, right?
No, I think because we have the WIPO overview, they call it, the WIPO overview 3.0, which has all the cases and it has like a standardized formula. So all panels right now, because you got to understand the Walmart cases and all those Asta cases that I spoke about to provide in history, were decided many, many, many years ago, when panels were first deciding decisions. So a lot of panels, I think, well, some panels, I think not a lot of panels, some panels used to use a more trademark sort of approach, not quite fully sort of appreciating that domain name disputes it's an animal, it's a beast of its own, you know. It's a creation, it's a creature of its own. So it has its own specific set of how you are sort of supposed to decide disputes, and it is important to decide the disputes based on the elements that have to be satisfied. So by and large right now, all the panel decisions have become, they sing with each other right now. But to go to the question of forum shopping, okay, that is very interesting because, for example, a MyDRP complaint, yeah, if you file a complaint here for a MyDRP decision to be made, you have the option of either choosing a one-person panel or a three-person panel, and like most alternative dispute resolution proceedings, you have the option of choosing. Although, admittedly, I think the number of panelists for domain name disputes is quite small. And sometimes, out of conflict, you might be conflicted because at some point of time, you might have acted for the complainant, especially if it's a big complainant, I personally had that experience once. I had to file a complaint at the AIAC for, I think, 10 out of 20 of them were conflicted because they had acted on behalf of the complainant. So, and then we had to go to the rest, and then we were struggling because both parties must agree at some point. And getting a three-person panel it can be a challenge. So strategically, yes, there is a possibility where if the respondent wants to be difficult, they can sort of object. I think case counsel would have experienced this as well. But ultimately, I think there are enough number of panelists, and whatever may be the case, most case panelists are very experienced and will provide an appropriate decision, a safe and sound decision.
So Hema, are you saying that choice of panelists is more important than forum?
I think a panel has to be constituted, whether it's a one-person panel or a three-person panel. But in terms of, say, it depends on the complainant itself, the complainant company itself. Sometimes in their mind, they feel they might get a more even decision if they get a three-person panelist. Although I think a one-man panel is as good. And the costs, of course, are naturally different as well. For a three-man panel, for a UDRP proceeding, it's even more expensive, actually. MyDRP proceedings are not at all expensive. So you will get a sound decision, even if it is a one-person panel decision, because most of the panelists are very experienced.
The other speakers.
Sorry. Another thing that you mentioned was you mentioned a list of defenses: nominative, criticism, and fan websites. Now, in IP law, you probably come across the defense of acquiescence. So, similarly, let's say a fan website. There is a celebrity and there's a fan website. The celebrity knows about the fan website and has probably interacted with it at some point. Can they then again go and say that this site needs to be pulled down? Or will this doctrine apply there?
The panelists normally will look at the whole situation holistically, not only in isolation.
So it can be a defense.
Of course, yes. It will be taken into consideration. It is never a closed number of defenses that you are allowed.
So that was not an exhaustive list of.
Of course, no. Yes, yeah. We have obviously set out the defenses which are the most discussed, and again, going back to the overview, there is a sort of focus because the sort of fan side and criticism side defenses are the sort of popular defenses. So that's why we have focused on those. And not to say that it is a closed list of defenses, no.
Yeah, thank you. So unless the other panelists have something to say, I'm done.
The other speakers, would you like to comment? No. Perhaps we could take questions from the floor. Yes.
Thank you very much. Thank you, our distinguished panelists. I'm Dennis Chai. I'm from Hong Kong, and good to meet Stanley and Mr. Nam online. And it has been a long time not having seen each other. So my question is on domain name registration. Since the topic of this section is enhancing digital security and trends and importance of domain name registration, so our panel member has delivered a lot of knowledge on dispute resolution practice, best practice from different perspectives. So my question is regarding the domain name registration. As we all know that why there are so many disputes on domain name arising out repeatedly, because that the domain name registration is based on first come, first serve rule, and there is basically no verification for the majority of domain name. That's why our domain name panelists and domain name lawyers are kept very busy. So that's why the cases will come in and it keep coming in, and there is it seems an endless story. The domain name registrant can just make a minor variation to the name. They can register a new one, so that as a brand owner, they have to repeatedly engage in domain name dispute resolution. So our center will be happy because the caseload will be increasing. Our panelists will be very busy. Of course, there's a very esteemed panelist fee. And so my question is, there was a few limited top-level domain name which implemented a verification process, like for example, the dog bank and dog pharmacy, and also the Chinese dog trademark, which I was involved. I'm not sure whether how does this domain verifying top-level domain name do nowadays, and from perspective from the perspective of a user or consumer or brand owner, what do panel members view on whether this verifying domain name can help and enhance the security of domain name? So that's my question.
Who would like to take this question? Yes, Dr. Lai. Are you on mute, I think, Dr. Lai?
Can you hear me?
Yes. Now I can.
Yeah, we can.
Yeah, great to hear from you, Dennis. It's been a long time. I would just make a general observation. I think the verification procedures do help, but they are limited because they don't cover all top-level domains. And as far as I know, I don't think they apply to CCTLDs. So you're always going to have a limitation on that unless there is a way for registration authorities to scale up. But because if you look at the cost involved in maintaining a top-level domain name server or repository, I'm not sure whether it will be solved, which is why I think in my presentation I'm trying to allude to more ground-level initiatives by registrants and also by companies to try and safeguard their own domains at a ground level. So I think it is a combination of both processes. One hopes that technology will make it easier for verification, but as you correctly pointed out, it's quite easy for scammers to just use a one-letter difference, and then to a person who does not pay attention to every single letter in the domain name, they can fall prey to actually a very similar, almost closely identical domain name, but with a one-letter difference, and that suffices for the scam. So I hope I answered that question.
Yeah, thank you, Stanley. Yes, I do. Thank you very much.
Anyone wants to add anything? You know, the defensive registration strategy, because there are so many permutations for a trademark, for instance, it is almost impossible to register every permutation. So that's kind of difficult in a strategy to implement. Would you agree?
That's a great point. But I also like to think that because it is impractical to register every foreseeable or unforeseeable permutation, that's what makes the domain name retrieval policy, that's what gives credence to it. So it's a risk management exercise. You want to maximize protection based on what you perceive to be the broadest possible slate of variation, coupled with security measures that are alluded to, such as DNS-SEC and so on. And then for the rest, the client will then have to be advised that it's the dispute resolution policy that is given. And if you're not happy with the outcome of that policy, then take your case to court. I remember years ago, in 1999, I think I must have brought the first domain name retrieval in Singapore, but I had to go by means of passing on, and bring a case in passing on in the state courts, as it then was. It was a laborious process, 6 months. And then you almost see a complete difference when you have the SDRP or the UDRP kicking in to meet all these retrieval.
Thanks. Yeah, it's a risk assessment that each company has to make. Any other questions?
May I add one?
Sure.
May I add one remark? It's nice to see you, Dennis, here, Kai. It's a long time no see. And good question. As Hemalata properly pointed out, the use of the URS options would be very, very effective to control the repeating the domain name cybersquatters registration, because it's very fast and efficient and very less expensive. So we have to make some enlightenment campaign for the public to use, right holders to use the URS system.
Thank you, Mr. Ho. Questions from the floor? Yes, 5:21. So I think we can end our session now. Thank you for your kind attention, for those of you in the auditorium. Yes, let's thank all the speakers as well.
Thank you to our panel speakers. Thank you to Mr. Ho Hyun Nam and Dr. Stanley Lai, very kindly joined us virtually. And we're looking forward to hosting you both here physically at a conference in the future. With that, ladies and gentlemen, we've come to the end of this year's ADNDRC annual conference. Before we go, I'd like to invite our Assistant Director, Ms. Heather Yijing Hua, on stage to present a token of appreciation to our panel speakers who are here physically. We thank all of you who've stuck on. I know it's a late Friday evening in December, and with the COVID scare and traffic, we really appreciate you all staying in. And our 250 virtual attendees that have stuck on since the morning, we really do appreciate that as well. We'd also like to take this opportunity to thank our supporting organizers, HKIC, CTEC, and KidRec for their continuous support. Without taking much more of your time, I'd like to invite you all to join us at the seminar room above the car park for a networking session to round off the conference. Thank you.